Garden State GSCLE. 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 Garden State GSCLE.
Good morning, everybody. Welcome to cross-examination, summation, and the use of perfect knowledge. That's what this CLE is all about today. Let me first of all introduce the Honorable Joseph P. Rem Jr., certified criminal trial attorney, and Jerome Ballarata. You're not certified in anything. You just tried a million cases.
I'm not certified in anything, no.
Certifiable. We're all certifiable.
We're all certifiable. By way of a background, a couple of introductory remarks. We're going to be talking about cross-examination, but on a much higher level than you guys are used to. And I want to propose to you I don't want to use the word revolutionary. That would be kind of ridiculous, but a novel way, that's a better way of phrasing it, of looking at cross-examination, analyzing cross-examination, and conducting a cross-examination, okay? And one of the things I'm going to ask you to do as we go through this is never lose sight of the relationship between cross-examination and your summation, because one of the things you're going to be thinking about strategically is how is this cross-examination going to play out during my summation. And from some of the cross-examinations we're going to practice with today, you'll see that you, even as a stranger sitting at a counsel table, could stand up following this cross-examination and give an enormously effective summation, just based on what happened during the cross-examination. You'll see that this works for anything, criminal cases, civil, matrimonial. It's really going to be the same all the time. Okay? Now, with that having been said, let's kind of get into our notes here. I want to start off by taking a look at some of the traditional ways of looking at cross-examination, and the best one I can come up with, this is from the last century, is the late Professor Irving Younger's 10 Commandments of cross-examination. Now, I have to tell you, I have the greatest respect and admiration for Professor Younger. He's an enormously engaging, wonderfully entertaining, inspirational professor. He passed away way too early in life, but I'm happy that his classes are preserved for everybody to see on YouTube, and I commend them to you. His lectures on evidence are really fabulous. He just makes the whole process fun. His 45-minute lecture on the 10 Commandments of cross-examination are certainly entertaining. And he's the first to admit that there really aren't 10 rules of cross-examination. There are fewer than that. He just makes 10 because it's easier for people to remember, all right? Now, the idea here, though, is that these 10 rules are applicable for any type of cross-examination you would run into. And in a sense, they are if you look at them from a tactical standpoint, okay? So just kind of going through them. These are very basic. Be brief. And the brevity here is really intended that with the idea that jurors have a very short attention span. You know, you take into consideration the ideas of primacy and recency. They're going to remember the first things they heard, the last thing they heard, and kind of lose everything in the middle. So he analogizes them to a coffee cup. You can put a certain amount of information in, but eventually the coffee cup just overflows the more and more you put in. And you stand the chance of drowning out points that you might have made earlier on. They just kind of get washed out by excess information, way more than the jury needed to know. Better to make your points and get out quickly. Next, use plain words. We have one mantra that we say. The largest word we will ever use in court is?
Delicatessen.
Delicatessen, okay. Everything bigger than delicatessen, forget about it, okay. Let's see. Use only leading questions. Now, this is a control issue. And we'll talk about witness control techniques momentarily. But the use of leading questions, only leading questions, is designated so that you will maintain complete control not only of your witness, but also of yourself, the story you have to tell to the jury through the witness's testimony. Be prepared. Being prepared, of course, you have to be prepared in any aspect. That's just regular diligence, okay? But being prepared in our sense is significant. It has a strategic component to it because it helps you acquire what we're going to be seeking throughout every case, which is perfect knowledge. And we'll talk about that momentarily. All right, listen. I can't stress enough about this concept of listening, but it's more than listening. It's watching, listening, and being there, not only during the direct examination, but during the cross-examination as well. I'm going to suggest that you follow the rules. You'll see F. Lee Bailey talk about this a little bit. Put your pencil down, put your paper down, and just look at the witness. Watch the witness. Listen to what he says. But pay particular attention to voice inflections, internal inconsistencies in his statement. Watch the body language. Watch how he moves his hands, feet, arms, the position of his body as he's speaking. And trust your instincts. If you see something there that doesn't ring true to you, that's something you're certainly going to want to exploit on cross-examination. You can't do this if you're sitting there like so many young lawyers do, and they're writing down every question and the answer the guy gives, and they completely lose the opportunity to see what's really going on. As F. Lee Bailey says, when a witness is lying, it's in the eyes. Well, you're not going to see what's going on in this guy's eyes if you're writing all kinds of goofy notes that don't amount to a hill of beans. Listen, pay attention to what's going on. Don't quarrel. That's just kind of standard stuff. You certainly don't want to be arguing with the witness, because then you have two fools arguing. Avoid repetition. I guess that goes back to being brief, and you're certainly going to get objected on for it, asked and answered. And also, you have the opportunity, to just bore the jury to death by asking the same question 40,000 times. Do not allow the witness to explain. That goes back to these control techniques we were talking about before, and we'll discuss different ways you can kind of stop the witnesses from doing it. Many times the attorneys, when they're propounding their questions and the witness wants to kind of go on, they'll hold their hand up like a police officer, and they'll say, "Thank you, doctor. Thank you, sir. That answers my question. I have another question for you now," that type of thing, to keep the witness from having an opportunity to go on and explain these things away. Of course, you can obviate all this stuff just by framing a proper question on cross-examination. Limit questioning. Again, this goes back to this whole idea of time issues and kind of keeping the whole thing in a reasonable period of time so the jury's going to remember whatever points you had to make. And finally, save for summation. And this is, of all the things he's talked about, we look at this from a strategic standpoint in our view of cross-examination. I want you to think about cross-examination and summation as two sides of the same coin. They are inexorably linked, okay? So everything you're doing during your cross-examination should be done with the mind of, how's this going to play out during my summation? What am I going to say about this guy? What is the significance of this cross-examination? What kind of commentary am I going to make? Now, one of the things you'll hear me mention several times today is this idea about not asking the last logical question, all right? And that's critically important, not so much from a control technique, but from a psychological standpoint. If you let the last logical question not be asked, it gives you two things that you can do. Number one, you can pose the question and answer it during summation. But more importantly, it's critically important to leave something for the jury to figure out. Let them solve the mystery. Take them right up to the edge and invite them to solve the riddle, all right? And the reason why this is important is because when a juror thinks that he has figured out a mystery, figured out some conundrum, okay, they become very proud of their work and very wedded to their opinion, okay? And it's very hard to shake them from that opinion because this is what they figured out. If you're lucky, you'll have two or three jurors that all come to the same conclusion simultaneously, and those three will then start to work on the others to kind of get them to go along. But this is very subtle how you do this, and your cross-examination is the major engine that you utilize to kind of get to that point. And we'll show you several examples about attorneys who very skillfully do this and just stop short to allow the jury to do their job. Okay, so this is a quintessential 20th century view of cross-examination, primarily tactical. We're going to take a kind of a different view of cross-examination today. And every time you have a witness that takes a witness stand, I want you to ask yourself three questions before you do anything. And you can do this really fast. Question number one, do I really need to cross-examine this guy in the first place? I mean, why would I cross-examine him? What's to be served by questioning this witness? If the witness hasn't brought anything to the table, hasn't said anything, hasn't advanced anything, hasn't hurt your case, there's no point in cross-examining this individual. Or the witness has been helpful. Didn't say anything to hurt you at all. In fact, his testimony was positive, either intentionally or otherwise. Why would you want to ask him additional questions? If the witness was absolutely devastating to your side, you run the risk when you cross-examine him of just really underscoring the things that he said that were devastating, okay?
As Irving Younger said, be brief. Well, we all agree on that, because when you're trolling in the other side's strength, they have a witness on the stand. They put that witness on the stand because they believe that witness is going to hurt your client. You don't want to go mucking around and uncover other things that they have to say negatively about your client. But I always thought it was very dramatic as a defense attorney when the state puts on a witness and that witness just has not hurt you. Or maybe it's just a technical witness and you don't have any defense to that. You just simply say, "Thank you, Your Honor, I have absolutely no questions of this witness." And the jury gets the idea like, wow, he wasn't afraid of that witness at all. It may be just show, and maybe that witness put a dagger in your heart, but you can't get around it, or maybe that's an element that you're ready to concede because you have a different defense. So if you don't have to cross-examine, don't cross-examine.
And then you may have a witness about whom you have so little information, and the prospect of catastrophe is so great that discretion is a better part of valor, and you'd rather forego that and try to win your case in some other way. So there are ideas that come about where it's just not a good idea to cross-examine a particular witness, and you've got to make these decisions on the fly as you go forward in the context of what the witness has said. Many times younger attorneys will feel they have to cross-examine a witness just because they have to, and that's really kind of an amateurish way of approaching these things. By the same token, though, you do get into situations where a witness has provided really bad evidence against you, and you just have to cross-examine this individual. There is no choice to it, and if that's the case, then you go forward and do your job. Secondly, what do I know about this individual? Now, this is what we talked about before, and I'm going to come back to this in about 2 seconds, about this idea of knowledge. And there's 3 levels of knowledge we'll be talking about. Perfect knowledge, which means on some aspect of this witness's testimony, you have perfect knowledge, perfect information, okay? You've got him locked in. He's going to have to own it. He's not going to be able to get out of it. And all right? There are techniques you utilize when you have that level of information. And remember, it doesn't have to be on everything the witness has said. You can do it on one very narrow part of his testimony, and that's going to be enough. The second type of witness is going to be the witness for whom you have imperfect knowledge, okay? You know some about what this guy has said, either from your own background or reports, or just from his direct testimony. But your information, your knowledge base is imperfect. There's a lot going on out there about this guy that you don't know. And what you're going to attempt to do during your cross-examination is to leverage what you do know against what you don't know and try to create perfect knowledge. Once you've created the perfect knowledge, you're going to be able to come back and do a really good job. And then the last type of witness is the witness for whom you have no knowledge, nothing, zero. This is a rebuttal witness. This is somebody that you'd never heard of before, somebody that you kind of got by you in the discovery, okay? For whatever reason, you just don't have a basis, a knowledge basis to cross-examine this witness, all right? This happens. We'll talk about how you treat those people as well. Just to keep things a little bit shorter, instead of having 10 commandments, I just want to have the word ACE. It's very easy to remember. We've talked about this already. The A, attention. Pay attention. Watch the body language, listen to the tone of voice, think about the logical inconsistencies of the testimony.
Bobby, let me just mention this about writing, taking notes. You're also sending a subliminal message to the jury. If you're writing, now sometimes judges let jurors take notes. But if you've got your head down and you're writing, the jurors are going to say, "Phew, this guy must be saying something really important." And you give a lot more credibility to what he's saying than if you were standing there going, And
you'll miss opportunities.
Control. Control questions. Controlling the courtroom. And most importantly, controlling yourself. We're going to see samples of cross-examinations today where the attorneys completely lose it. They become emotional, they fight with a witness, they fight with their adversaries, they get into arguments with the judge. And what that does is it steals all the heat from the cross-examination in the sense that the jury is now paying attention to the attorney and to this drama that's going on that has nothing to do with the case at all. And by the way, the drama is usually way more interesting than the case. But the problem is that the questions that are being propounded to the witness and the answers the witness are giving are completely lost on the jury. They're not paying attention to that. They're paying attention to this fight that everybody's having in court. All right? We'll show one cross-examination. This is a case that took place in Ohio. It's actually painful to watch because the level of professionalism is so Their unprofessionalism is so stark. It's just embarrassing to watch this kind of stuff. All right. We'll also discuss a couple of additional tactical things in terms of the use of leading questions, witness control techniques, and things like that. And finally, exploitation. And this is probably the most important aspect. Again, it's amazing to me. I see attorneys coming up to do a cross-examination. They've got like yellow pages of notes, you know. You just can't be doing this stuff, okay? The idea about paying attention not only is included in watching the direct examination and listening to the direct, but also during the cross-examination. You've got to pay attention to the witness's body language during cross-examination and listen to verbal cues during that time period. We're going to take a look at a videotape in a few moments where there's an attorney conducting a cross-examination, and the witness does something very, very telling with her body language. The attorney does not pick up on it. He's too focused on the questions he's asking and doesn't see what she's doing. And when we get to it, you'll see that if he had just picked up on it and talked about it, saved it for summation, it would have had an enormous impact on the jury, but he didn't, okay? So, we have this idea of exploitation, and there's one additional thing I want you to kind of visualize as these cross-examinations go on. Like we're building a tree, like we're God, we're inventing a tree, okay? So, the first part of the trunk of your tree is a question, okay? The witness, so you propound the question to the witness on cross-examination. The witness answers. Now what you want to do is build a branch based upon that particular answer and start questioning the witness on those things. Bias, interest in the outcome, just an out-and-out lie you can impeach them on, whatever it may be. Doesn't make any sense. And then as a result of those answers, there may be another twig or two that comes up which you're going to want to proceed. So you have a main trunk and then one branch, and that branch may lead to other branches, okay? When you've exhausted that, you come back and ask your next main question in the trunk. You'll get an answer from the witness, it'll go off on this way, and now you'll start questioning the witness, follow questions on whatever statement he did to your initial question, okay? And again, you may get into side issues that come up as you go along. You have to be prepared to exploit answers as they come up. And as attorneys, we've been practicing for a long time. I mean, how long you've been practicing, what, 35 years now?
36.
36 years. Come on, give me a break.
Yeah.
I mean, enough is enough, all right?
Longer than Kathy's been alive.
Well.
Oh, yeah.
It's actually, I look at him and I said, every day that he's been on earth, I've been practicing law, which is either something bad for him or bad for me. Probably bad for me. But the point is that over 36 years of standing in courtrooms all over the state of New Jersey, you develop instincts. You just do. You can't put your finger on it. You just know because this is what you do every day of your life.
I had one yesterday.
Okay. So when you got to trust your instincts, and you see that he just equivocates a little tiny bit, or his answer's a little bit different, or you saw some shift in his body language, it may be completely just go over everybody's head, not you, because of your training and experience and your instincts. You got to trust your gut. Say, I want to talk to this guy about that, because sometimes a little tiny opening, all of a sudden, the witness will basically collapse on that because they're hiding something that you've picked up on. This is not for the faint of heart, and certainly not for new attorneys. Okay, so attention, control, exploitation. When these things come up, you're going to exploit them. All right. Here's our 3 types of knowledge that we've just discussed. Perfect information or perfect knowledge, imperfect information or imperfect knowledge, and no knowledge. Okay? All right. Let's get into this then. And I want to just start off with the no information, no knowledge witness to begin with. Remember, the initial question is, do I really need to cross-examine this person? And there are special dangers fraught with somebody about whom you know zero, because you just don't know what the witness is going to say. You have no way of knowing. All right. One of the attorneys says to me, one guy in particular said, look, this is a cross-examination in the blind. You should have very, very low expectations for a witness about whom you have no information. What are you going to talk about? We always have, with every witness, no matter who he is, you're always going to have issues related to credibility, bias, interest in the outcome, perception, very important, motive also, and any inconsistencies, logical gaps in the direct testimony, or logical gaps in the cross-examination as well. The key is, I think, when you're dealing with this type of witness, that if you can make a point, make it and get out. Sit down, okay? Get out while you're ahead. because it's just too dangerous to continue a cross-examination when you really don't know where you're going in the first place. This is how you wind up getting burned. And oh, by the way, this whole concept of primacy and recency and brevity, all these things are important in the sense that the jury's more likely to remember that you've made your point if you just kind of do it, sit down, and you kind of move on. All right? And again, just as we said a moment ago, trust your instincts. Short questions to exploit unexpected targets of opportunity if and when they arise, especially from voice inflection, body language, logical inconsistencies with testimony. All right. Now, I'd like to take a look at a movie. You guys have seen this movie 1,000 times, I'm sure. But it needs some discussion ahead of time. All right? So this is 1982, The Verdict, Paul Newman and James Mason, directed by the late Sidney Lumet. And one thing with all the movies that Sidney Lumet directed, he's just an absolutely marvelous director. He'll go down as one of the giants in the history of cinema, certainly for the 20th century. He knows how to tell a story, all right? And this is quite a story. It's enormously engaging and very, very entertaining, and that's perfectly fine. But I have to tell you, for the scene that we're going to watch, they must have had a cadre of the most experienced attorneys in Massachusetts come in and advise them on how to do it. Because this scene is so nuanced and so subtle, it'll be completely lost on just the regular lay audience. But for attorneys watching it, we pick up on what's going on here. Now, I'm not going to interrupt the scene out of respect to Sidney Lumet and to the other actors, the people involved in this, because this is really a work of art more than anything else. And out of respect to them, I'm not going to interrupt the film in any way, shape, or form. However, I do want to kind of give you a setup, and I'd like you to pay attention to some particular aspects of this. Now, here's the setup. We have a medical malpractice trial, and the defendant is testifying, and he's being cross-examined by the plaintiff's attorney, Paul Newman, okay? Now, the doctor who's on trial is an anesthesiologist, and he's a bit of a wise guy. He has one of these God complexes, which so many of these doctors have, because in the operating room, they really are God, all right? And he just has to be the smartest guy in the room. Now, earlier in the movie, you see him being prepared to testify, okay? There's no problem with that, except they forget to tell him the one single piece of information that you should repeat to your client over and over and over again to get him ready for direct examination. What do you tell him to do?
Don't volunteer.
What's that?
Don't volunteer.
Say it again.
Don't volunteer.
Got it? They don't tell him that. So watch during this cross-examination where there'll be a question propounded to him. He answers the question, but then he's got to volunteer. He's got to add something on which was not in the question. He could have just said yes or no. But since he's got to be the smartest guy in the room and he's a wise guy, he wants to volunteer. Okay? Totally unnecessary and had not been properly prepared by his counsel. All right? Paul Newman is laying a trap. He does not ask the last logical question to the witness. Stops, rests. Now it's time for the rebuttal case. Paul Newman calls his rebuttal witness. And the second thing that the defense attorneys had not told their client is this. The jury is watching us every second. They're paying attention to us. They're watching the way we sit, the way we interact with each other. They're watching us in the courtroom. They're watching us outside in the hallway. They're watching us at lunch. They're watching us all the time. We've got to constantly be aware of that and broadcast a message of confidence and righteousness in our position. I mean, that's what you have to do. This witness was not told that. So when Paul Newman says the word naming this witness, her name is Caitlin Costello, you'll see the doctor is thunderstruck. It's like somebody put an electric shock through his body. He's totally panicked. And the jury picks up on this. They see his panic. Notice that while she's walking into the courtroom and getting ready to take the oath, he stands at counsel table. He's so shocked by this. His attorney is oblivious to it. He should be grabbing the guy and having him sit down. It's not to broadcast that there's a problem with this witness. Okay? And you see when the witness takes the witness stand, there's glaring back and forth between the two of them. The jury's got to be saying, what's this all about? Why is he acting this way all of a sudden? It's so different than the way he's been. You know, we had a guy who was completely confident and a wise guy. Now all of a sudden he looks like he's just gotten the death sentence. You know, what's going on between these two people? Pay attention to the blocking. the way that Paul Newman uses the entire courtroom during his direct examination of this witness. Whenever he's going to propound a question that will have devastating information about the doctor, he walks over to counsel table and stands next to the doctor so that the jury is paying attention to this witness who's just testified before them, and there's direct testimony coming back impeaching what he just said. When he has a question, he wants the jury to be really, really clear on and to understand what the answer to the question is. He walks over to the jury, turns his back to the witness, and he's looking at the jury to kind of emphasize with his eyes and his body language the answer she's giving to the jury. Okay? Again, notice that he does not ask the last logical question. He lets it hang. Now comes time for cross-examination. And you'll see James Mason, as a defense attorney, turns to his witness, because he doesn't know anything about this lady at all. She's a rebuttal witness. He says to his client, "Anything?" And the doctor goes like that, shakes his head no. Now at this point, Andrew, I know what you would do. You'd say, "Your Honor, I don't know anything about this witness. I'd like to have 5 minutes of my client to prepare my cross-examination." Every judge in the world is going to say, "Fine." All right? No one's going to make you do that. You will then go out, take your client into the men's room, and beat his head against the toilet until he tells you who this person is, why is she here, why are you acting this way, what is she going to, what can I talk to her about, okay? But his client is completely uncooperative. He decides, rather than ask for an adjournment, he's going to stand up and conduct a cross-examination of this witness about whom he knows nothing in the blind, okay? Now, as I said before, you always have issues of credibility, inconsistency, interest in the outcome, all that stuff is always in play. And you'll see that when he begins the cross-examination, as long as he sticks to these general issues, he's doing pretty well, okay? And although I don't know that you could actually say that he has her impeached at any point, if he had just stopped, quit when he was ahead, he would have at least neutralized her. The jury would not have taken her particularly seriously, okay? And it was only 3 or 4 questions into it that he got to that point. He just should have sat down, and that would have been the end of that witness. Her effectiveness would have been over. But he smells blood in the water and starts to get carried away with himself. And he begins asking questions in a way predicated to lose control over the witness, like when, how come, things of that nature. You would never ask a witness because you're just surrendering control of the examination to the witness when you begin questions like that. One thing in particular where he thinks he's gotten 2 different sides of the story out of the witness, and he starts asking the witness, well, which is the lie? Which is the truth and which is the lie? All right? I think that that's one of the worst things you can ever ask a witness. Why? Because when you stop to think about it, who cares? What difference does it make which is the truth and which is the lie? It doesn't matter. You ask the jury that question, okay? Because the witness is not worthy of belief because you've gotten 2 different stories out of the witness. Who cares which is the truth and which is the lie? It doesn't make any difference. It's a bad question to ask on cross-examination. So instead of quitting when he's ahead, he decides he's going to press on because, again, he's a little bit of a bully and he smells blood in the water. But don't lose sight of the fact you're dealing with somebody about whom you have 0 information. So she surprises him with an answer to an artfully asked question. Not a leading question at all. He's surprised and shocked by her answer. He then gets an adverse evidentiary ruling. And the adverse evidentiary ruling ruins him. He has completely lost focus, okay? And now he does the one thing that no one ever wants to do in court as a cross-examiner. He asks not 1, but 2 consecutive questions, beginning with the word why. Okay? And I have to tell you, the minute he says the word why, the trial is over at that point. That's the end of the case. Let's take a look at the verdict, 1982, directed by Sidney Lumet, Paul Newman, and James Mason.
Dr. Tower, page 406, contraindications of general anesthetic. Ideally, a patient should refrain from taking nourishment up to 9 hours prior to induction of general anesthetic. Does that sound familiar?
Yes, I wrote it.
Methodology and practice in anesthesiology, a general textbook on the subject, is that correct?
Yes, it is.
And you wrote it?
Yes.
Page 414. Patient has taken nourishment within 1 hour prior to inducement. General anesthetic should be avoided at all costs because of the grave risk the patient will aspirate food particles into his mask. Is that what happened to Deborah Ann Kay? She aspirated food particles into her mask.
She threw up in her mask, yes. But she hadn't eaten 1 hour before admission.
If she had eaten an hour before being admitted to the hospital, then the inducement of a general anesthetic of the kind that you gave her would have been negligent?
Negligent? Yes, it would have been criminal, but such was not the case.
Thank you.
Mr. Concannon?
No further questions, Your Honor.
Thank you, Dr. Howell. Mr. Galvin? Rebuttal?
Caitlin Costello Price.
Caitlin Costello Price.
State your name, please.
Caitlin Costello Price.
Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated.
Caitlin Price.
Yes.
You were the admitting nurse at St. Catherine La Brea on May 12th, 1976, the night that they admitted Deborah Ann Kay.
Yes.
Did you sign this admission form?
Yes.
Those are your initials, KC.
Caitlin Costello. That's my maiden name.
Did you ask the patient, when did she last eat?
Yes.
What did she say?
She said she'd had a full meal 1 hour before coming to the hospital.
1 hour?
Yes.
And did you put the numeral 1 on this admission sheet? I mean, standing for 1 hour.
I did.
A single hour.
Yes.
Thank you. Your witness.
You're aware of the penalties for perjury?
It's a crime.
It is a crime, a serious crime.
I wouldn't do it.
You would not.
No.
In fact, you've just taken an oath that you would not commit perjury. You've just sworn to that, isn't that right?
Yes.
Just now.
Yes.
You were sworn before God that you would tell the truth.
Yes.
Now, I want to ask you something. 4 years ago, when you were working as a nurse, are you aware that these doctors, Marks and Towler, based their treatment of Deborah Ann Kay on this admitting form, which you signed? Wasn't that an oath? These are your initials, KC. When you signed this form, you took an oath, no less important than that which you've taken today. Isn't that right? Isn't that right?
Yes.
Then which is correct? You sworn today that the patient ate 1 hour before admittance. 4 years ago, you swore that she ate 9 hours before admittance. All right, which is the lie? You know that these men could have settled out of court. They wanted a trial. They wanted to clear their names. And you would come here and on a slip of memory 4 years ago, you'd ruin their lives.
They lied.
They lied? They lied? When did they lie? Do you know what a lie is?
I do, yes.
You swore on this form that the patient ate 9 hours.
That's not what I wrote.
You just told me that you signed it.
I signed it, yes. But I didn't write a 9. I wrote a 1.
You didn't write a 9, you wrote a 1. And how is it that you remember so clearly after 4 years?
Because I kept a copy. I have it right here.
Objection! You can't be expected to accept a photocopy when the court already has the original.
I'll rule on that presently. Please, proceed.
What in the world induced you to make a photocopy of an obscure record and hold it for 4 years? Your Honor, this... Why would you do that?
I thought I might need it.
And why would you think that?
After the operation, when that poor girl, she went into a coma, Dr. Towler called me in. He told me that he'd had 5 difficult deliveries in a row, and he was tired. And he never looked at the admittance form. And he told me to change the form. He told me to change the 1 to a 9. Or else he said he'd fire me. He said I'd never work again. Who were these men? Who were these men? I wanted to be a nurse!
No further questions, Your Honor.
You may step down.
If you say which one is the truth and which one is the lie, you're going to find the witness is going to say, well, look, they're both the truth in a way, and they're going to give you an explanation which is going to undercut everything that you can tell that jury in summation. As Jerry knows and as you know, you always want to save that last logical question for summation. Why? Because if you make your point on cross-examination, your adversary, the prosecutor, the defense attorney, whoever it may be, will come back on redirect and clear up that mess and get the straight story before the jury. But they can't do that to you in summation because all the testimony is closed. In summation, your point that you're going to make is unassailable because there's no more testimony after that.
This thing about not asking the final question. And I have found, and I think that psychologically it's fairly accepted, that when a jury goes into the jury room, they will have lots of facts and information that they will use to support their position. And they may defend their position with this facts and information. But a juror will fight to the death to protect a fact that they've discovered themselves during the course of a jury trial. So if you don't spoon feed it to them, and they think I figured this out on my own, this is what they said, you've got a much stronger advocate in the jury room, an advocate that can turn the entire tide of the case. But the interesting thing that I found about that video is that Paul Newman didn't ask her about the copy, okay? Didn't ask her, didn't raise it at all that she had made a copy. So, and that was critical. And I think in the movie, the judge, doesn't the judge let it, does he let it in? I don't remember whether he lets it in. But they've got the testimony.
That's right.
Well, what if James Mason didn't cross her? What if his client had been truthful with him and said, we're in deep trouble. I told her to change that form. Now, think about where her testimony was when he stopped her. She says, well, what did she say? I wrote a 9. I didn't even know that she even said that. She said that she wrote a 1. She said, I wrote a 1 on the form, indirect. And then he stopped. Well, what if he knew, if Mason knew what really had happened, and he said, well, I don't have any questions to this witness. He's got the form that says 9, no one's got hurt, she said a 1, and doesn't ask her any questions. None of that comes out.
So, this is a good example of what happens when you don't quit when you're ahead. Okay? Did you guys see, though, that he really, in the early stages, he really kind of neutralized her? And just inexcusable to ask questions, how come, why, just letting questions, open-ended questions like that to let the witness explain away whatever the witness is going to explain. Just inexcusable. That's what happens when you lose focus. Now, we'll take a look at a different type of cross-examination, again, with the witness who really has you have no information about this witness. This is a defendant who's testifying in a murder case, okay? And the prosecutor in the case is done by Professor Charles Rose here. He has a very interesting way of conducting the cross-examination. Notice that he does not propound questions to the witness at all. What he does is he makes a series of declaratory statements, each statement having one fact in it. Okay? And all he's doing is making a declaratory statement and then waiting for the witness to ratify the correctness of that statement. Then he'll make another statement. It's almost like he's testifying directly, all right? Or in a sense, he's making his summation and doing it with the cooperation of the witness, okay? And you can do this if you're very highly skilled. Now, he has perfect information to the extent that he's listened to the direct testimony. So what he's doing is just rehashing the direct testimony that the witness gave and then asking the jury by implication to draw certain inferences from that testimony. And that's perfectly fine. But I want you to pay attention to the use for impeachment purposes of bias, interest in the outcome, prior dishonest statements that this individual has made, motive, and internal inconsistencies in his testimony. All right, all coming out through this cross-examination from a witness about whom he really does not have complete knowledge. He just really has no knowledge at all, except for what the witness has already said on direct.
Mr. Hightower, you had a .45 caliber gun in your hand the night Chris Alexander was murdered.
Yes.
It was in your hand and you were looking at the Alexander home.
Mm-hmm.
You didn't see anyone outside when you looked out the door.
No, I didn't.
You did not see a car in the driveway.
No.
You did not hear the screeching of tires.
No.
But you had a .45 caliber gun in your hand.
Yes, I did.
And that gun was your weapon.
Yes.
And it's loaded with .45 caliber ammunition.
Yes.
Were you aware that .45 caliber ammunition was dug out of the floor of the Alexander home?
No, not to now.
Okay. Were you aware that the weapon that killed Mr. Alexander was a .45 caliber weapon?
No, not to now.
Not till now. Of course, your weapon's never been tested.
Correct.
Well, your brother is the chief of police.
Yes, he is.
And your brother came to talk to you that night.
Him and along with other detectives.
Yeah, Detective Morris wasn't there, though.
No.
You gave a statement later about what happened.
No, I gave a statement then.
Your brother was the first cop you talked to about this.
Mm-hmm.
And we can agree that you called your brother after the shot was fired.
Yes.
Now, you don't like Chris Alexander very much, do you?
Not really.
I mean, he's involved in drugs.
Mm-hmm.
A bad person to have living across the street from your family.
Yes.
From your wife.
Mm-hmm.
From your kids.
Yes.
A threat to the neighborhood, huh?
A big threat to the neighborhood.
Big threat. Well, he's not a threat anymore, is he, Mr. Hightower?
No, not to the best of my knowledge.
Well, he's dead now, isn't he?
Yes, he is.
Now, you have had your own issues with the law in the past, haven't you?
Yes, I have.
You have actually lied to the federal government about money before, haven't you?
No, I haven't lied. I just didn't record a $10,000. Yes, it wasn't a lie.
Well, I mean, you know, when you tell the federal government on your income taxes how much money you've made, that's a sworn promise, right?
Yes, it is.
And you made a promise that was not accurate.
Correct.
And that was for your benefit. You didn't have to pay taxes on that 10 grand.
Right.
Although eventually it caught up with you.
Yes, it did.
And once it caught up with you, you paid it off.
Yes, not a problem.
But that was a time when you were not honest to someone.
Correct.
You've also had drug issues in the past yourself.
No, I had drug issues with my brother.
You have drug issues with your brother. Yes. So your brother's drug issues became a problem in your life?
Yes, it did.
And your brother has really never recovered from having these drug problems.
Right.
And Mr. Alexander, according to your testimony, was one of his sources for his drugs.
Yes.
He won't be selling your brother drugs anymore, will he?
No, not to the best of my knowledge.
Not to the best of your knowledge, and I would imagine that that you know.
Yes.
I mean, you were awake that night.
Yes, I woke up from the gunshot.
And you had the gun in your hand.
Yes.
And he was across the street from you.
Yes.
And by your own testimony, nobody else was there at that time.
You had the 10 rules by Irving Younger. The rule that he did not have, okay, which I think should have been number one, is know the rules of evidence inside and out. Judges don't want you to know the numbers. Know the damn numbers. Know the subchapters. Know every case you could possibly know. Know the rules of evidence. He's asking him about this $10,000. This is judge object 609. It's not subject of a criminal conviction. He hasn't established that it's the subject. He never asked him that he said it caught up to him. But is that how he's cross-examining him? Pursuant to Rule 609, it's a prior conviction. Otherwise, it doesn't. Does it come in otherwise? Let me just take a minute, and I'll tell you. Know the rules of the federal rules of evidence, because he could get that in. Under Rule 608, if he makes a statement that is the subject of a dishonesty, he can cross-examine him on it under Rule 608, but he can't introduce extrinsic evidence to prove it. You're stuck with the answer. Read the rules. It's available. But what he did, there should have been an objection, because all he should have been able to say is, isn't it true that you were convicted of violation of 21 U.S.C. 7201, filing a false income tax? Isn't that right? That's all he should have been able to ask him. And when did that happen? Did you get sentenced? What was your sentence? Right. What was your sentence? Not what he did.
I think all of us now sitting in this classroom could stand up and give a compelling, persuasive summation in this case. This guy's as guilty could be. All right? And anything he said to you is completely unworthy of belief. He's an admitted liar, admitted perjurer. He has an interest in the outcome of this case. The circumstantial proofs show same gun, nobody else around, same type of ammunition. His weapon never checked. Why? His brother's the chief of police. You put it all together and it shrieks guilt. Okay? And you can do this, and you see this is the way he's setting up his cross-examination. Now notice, he does not utilize this tree and branch technique that we talked about. He's strictly tree. He's going to go forward and ask, he's not even asking questions, he's just propounding his theory on these declarative statements, which is perfectly fine. It's a technique. And notice as he's going forward, he gets, since he doesn't have perfect information, or he doesn't have really any information about this guy, is that every once in a while, maybe a half a dozen times during the cross, he gets an answer to a question that he didn't want, okay? Because his supposition is wrong and the witness disagreed with him. The key is, it didn't stop him. He just kept plowing ahead and plowing ahead and plowing ahead. He didn't lose focus on this because he got an answer he wasn't expecting. He just like you're playing cards, you just toss the card away and you keep on going. Same principle. Now, the next example we're going to look at is somewhat similar. This is a cross-examination of a witness for whom there is imperfect knowledge. Okay, you know some, not a whole lot, but you do know some, okay? The dialogue you're going to see has been taken from the trial transcript of this very famous trial that happened in 1964. This is the retrial of Clarence Earl Gideon after he had won his famous 9-0 decision in Gideon versus Wainwright before the United States Supreme Court. Of course, the court's decision had the net effect of vacating his conviction, and now it's remanded. The state of Florida was to try him again. The difference, though, is this time, rather than going pro se, Mr. Gideon has an attorney to represent him. Okay? Now, what I'd like to do is to split this in half. I want to take a couple minutes and watch a direct examination of the witness, and then I want to stop and I want to question all of you just to get your ideas about how you would approach the cross-examination of this witness based on the techniques we've talked about. Everybody cool? All right. Let's take a look at State versus Gideon.
This jury is acceptable, Your Honor. Acceptable, Your Honor.
They call you first witness?
Lester Wade. Lester Wade.
Well, raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. I do. Proceed.
Mr. Wade, where were you at 5:30 in the morning on June 3rd, 1961?
Outside the Bay Harbor pool room.
Who or what did you see?
Seen Clarence Earl Gideon inside the pool hall.
What else did you see?
Well, seen him come out with a pint of wine and then leave in a taxi. Then I went back to the pool room and seen it was busted into, cigarette machines busted into, coin box lying empty on the pool table.
Did you notice anything interesting about Mr. Gideon when he came up?
Yes, sir. His pockets was all bulging.
Your witness.
You have to cross-examine this guy. You just have to. All right. He's putting your client at the scene and raising the inference that he perpetrated this burglary. Okay. So, what do you want to know about this guy? So let's just look at these questions you're asking. Your first question is, what were you doing there that night? Okay. So what are you doing there? He's going to give you an answer. That's going to take you off on a branch of the tree. Because now you're...
Cross-examination. I mean, that's done a leading question, right? So you say the what? That's opening...
Well, you see, the thing is this. You don't know what the answer's going to be. You know he's there. What are you doing there? Okay? What were you doing there? Do you really care what he says? He's going to say X.
Yeah.
That's going to give you an opening now to have a tree, a limb on your tree, to start cross-examining him on that. What was he doing there at that time?
Then you can go with the lead. So you were there drinking.
Right. Or
You had multiple drinks.
Or staking the place out, or whatever it was. Okay. And then go back, and you're going to ask him another question. It may be with, how do you know Mr. Gideon? How do you feel about Mr. Gideon? Something like that. Bias or something of that nature. And whatever that answer is, then that may take you to a different tree with different branches. Make sense? What do you think?
Yeah, no, that was my first impression, but they were all open questions. So then my thought process is, I guess you have to think that some answers you don't care about.
That's exactly right. See, the open question is the difference between soliciting information on an open question and surrendering control to the witness. Okay, you're just basically getting to a starting point. Okay, it's a logical question that you don't know the answer to. I mean, you could say, isn't it true you were there to frame Mr. Gideon? But there's no basis for that. The better thing to do is to let the victim start the ball rolling, and then you can pick it up from there. Okay? Because maybe his answer won't make any sense. Maybe it'll be an absolute lie. Maybe it'll be inconsistent. Maybe you'll see something in his tone of voice when he answers the question, or his body language. Got it?
The other thing is you can get the jury thinking, why didn't the prosecutor ask these questions? Why didn't the prosecutor let us know why he's there? Maybe there's something we need to know.
Maybe there is.
Yeah.
Okay. But these are all inferences. You have any additional questions, Joey, just based on...
Yeah, because I mean, I guess my basic instinct is I don't want to ask the guy a question I don't know the answer to,
Right.
but I need to know this information too. Why were you there? How do you know him? What were you doing that night? All stuff you kind of ask openly in a deposition, perhaps.
Right.
But I see what you're saying, because it leads, I mean, you could say more harmful stuff, but then again, I don't know anything else about this guy.
So your first question, because again, you're not surrendering control to the witness by saying, what were you doing there? Okay? He's going to give you an answer. Now, everything else from that is going to be all leading questions. You see what I'm saying? As you exploit whatever he told you. That doesn't make any sense or whatever, or it's inconsistent with something he said before, whatever it may be. Okay? Now, the goal of every cross-examination, if you don't have it already, is to develop perfect knowledge. Okay? And the key is, we haven't talked about this, but I've kind of intimated in Andrew's domestic violence case, that when you have perfect information about a witness, either that you've gotten pre-trial or you developed during the direct exam or the cross-examination, there's a procedure that you utilize. Okay? And basically it calls for three things. Number one, the setup. You have to set your guy up. Number two, picking the right moment to lower the boom on the guy. All right? And number three, assuming a role. And this is where you become anybody you want to be and develop anything you think is going to be appropriate to get the message to the jury. You become Harrison Ford in Indiana Jones. You can become James Bond. You can become Laurence Olivier. You can be Al Pacino. You can be anybody you want to be. All right? And the reason you have the latitude to do this is because you know where this is going. And you know what the end is going to be. Because you're in total control of how the information is going to come out, when it's going to come out, what sequence it's going to come out in. Okay? So you're going to want to adopt an attitude that is going to underscore what you're trying to do for the witness, okay? Now, you'll see in this cross-examination that the attorney develops perfect information during the course of it, okay? It just happens. And I want you to watch how his personality totally changes and he starts acting in front of the jury. And he's very, very low-key and very subtle. But I think you would see from his body language, the attitude he's adopting is, this is a guy who is contemptible and is not worth any credibility at all. He's just a despicable, contemptible person. Okay? That he's not worth your time. Okay? But he does this through his body language. You'll see how he does it. Great lawyers can do this kind of stuff because they've been practicing law for 36 years.
Mr. Wade. What were you doing outside the pool room 5:30 in the morning?
Oh, I just come back from a dance in Apalachicola.
How'd you come back?
In a car with some friends.
Oh. What were their names?
I don't remember now.
You don't remember any of them?
Well, not right now.
Well, can you tell us what kind of car it was?
Yeah, old model Chevrolet.
These, friends of yours, how come they put you off 2 blocks from home when they just driven you 60 miles?
Yeah, I don't know. I mean, I didn't see no
What?
point. Well, I was just going to hang around there until the pool room opened at 7 o'clock.
Y'all been doing a little drinking that night?
A beer or two.
Where was that?
Apalachicola.
Well, now, Lester, the stores closed at midnight at Apalachicola. When you and your friends got back at 5:30, could you have still been maybe a little bit thirsty? Did you go inside that Bay Harbor pool room?
No, sir.
You didn't come out of there with a 6-pack of beer?
No, sir.
Well, now, you spend a lot of time around the pool hall, do you, Lester?
Some.
Well, now, there's always a lot of advertising boards in the window, aren't there? Now, how could you look in there and see somebody with all those posters?
Well, I did.
And the windows, they're kind of high up. I mean, they're almost too high to see through, aren't they? Now, you did not call the police, then or later.
That's right.
Have you ever been convicted of a felony?
No, sir. Well, not convicted. Well, I stole a car once and was put on probation.
Now, wait a minute here. At the first trial, when Mr. Gideon asked you if you'd ever been convicted of a felony, you said, "No, sir. Never have." That's a false answer, reflecting on Wade's character and his credibility as a witness.
It's not necessarily a false statement.
It is, too.
No, pleading guilty is not the same as being convicted.
Well, it's just exactly the same.
It's enough arguing about it. You both made your point.
Mr. Wade, have you ever denied that you were guilty of a felony?
Yes, sir.
When and where did you deny your criminal record?
Right here. In his last trial.
That's all.
I have to tell you, the key is when he asked the witness the question, have you ever been convicted of a felony? And he says, no. Okay. That gave him the perfect information. See, now he has him. And the guy's going to have to own it. So he can play it any way he wants. He played it subtlety, and his body language. Very, very subtle to the jury. This is a guy who's just not worthy of belief. Now, if I were doing it, I would have hammed it up a little bit more and asked him if when he testified the first time, did he take an oath? Did he raise his hand? Did he understand what an oath meant? Did he take an oath today? Okay? You see what I'm saying? Just so that you can argue to the jury at summation. This is a guy who just has no respect for the law at all. And you're going to, Now, there's a couple different ways you can handle the summation in this case, all right? And you got to be very, very careful you don't confuse the jury. You say, jurors, there's no doubt that somebody burglarized the Bay Harbor pool room on that day. There should be no doubt in your mind that that happened. And the question is whether the state has proved to you that Clarence Earl Gideon did this and proved it to you beyond a reasonable doubt. So in order to believe that, you're going to have to believe the testimony of a admitted perjurer, a liar, someone who took the oath and came before people like you in the community, not once, but twice, and lied straight out. But you can also try to solve this yourself. Who robbed this place? Who had everything to gain? Who was there at 5:30 in the morning waiting for an hour and a half for the place to open up? People really do that type of stuff? Who's the one who showed up drunk and still thirsty that day? The one who can't remember who he was with his friends, getting dropped off there a couple blocks from his house at 5:30 in the morning. Who's the one who never called the police? Never. Okay? And who stands to gain from coming in here and lying to you? Okay? Who is that person? Now again, you'll solve that yourselves. The key issue, though, is has the state given you reliable evidence from which you can conclude beyond a reasonable doubt that Clarence Earl Gideon did this? You know the answer already. We'll hear it when you come back with your verdict. Okay? Something to that effect, all right? But you got to kind of keep these two things separate because really who did it is not your mission. Your mission is that the proofs here are not beyond a reasonable doubt. Do you guys agree with me? I'm just giving this off the top of my head. I mean, I haven't played anything.
One more reason to think that he's biased and prejudiced.
Correct. Because he's the one who actually did it. So he has every reason to come in here and lie to this jury. And he's already lied to you. He lied to two juries. Okay?
But he stole something.
See? Got it? But also a good point. That he's an admitted thief on top of everything else. I was thinking about Joe Pesci this morning. And you got Joe Pesci and Danny DeVito. We have a lot of great actors that come out of New Jersey, I really enjoyed in the movie and the Broadway play, which I went to see, Jersey Boys, there's a little bit of a role that Joe Pesci plays, and they're all from the same neighborhood, these guys. And I have to include this movie in any time we do this kind of stuff because it's the most popular lawyer movie out there. I personally hate it. I don't like anything about it. It's just awful. But everybody likes it except me, so I have to go with it. Now, there's two things that come out of this scene and that are critically important. And the first one is demonstrations in court. It's tough enough doing a demonstration when you're doing it as part of direct examination and you've got a friendly witness on the witness stand. A whole lot can go wrong. I remember in the OJ case, Barry Scheck was doing a blood splatter demonstration with Dr. Henry Lee on the witness stand, and I remember he slammed down something to make a blood splatter go off. It was ink they were using, and it splattered all over Barry Scheck, ruined his shirt and everything. It was really kind of funny. So, I mean, things can go wrong even when you're in total control. I don't know that anybody in his right mind would ever conduct a demonstration on cross-examination, okay? And if you don't believe me, go talk to Christopher Darden, okay? And ask him what happened with those gloves, all right? I mean, that should be a lesson for all times for every attorney coming out of law school. This is just something you don't do. In this scene, Joe Pesci's going to break this cardinal rule and conduct a demonstration, all right? And that's fine. You should never do it, but this is Hollywood. What I want everybody to get out of this is something that's much, much more important, and that's his attitude toward the witness. This is a very sympathetic witness who the jury likes a lot. She doesn't have any stake in the outcome. She's just a witness, okay? Nobody asked her to be where she was when she saw what she saw. And what you'd have to say to them is, she is telling the truth. She's telling you the truth. She swore to tell the truth, and she's telling you the truth. It's just, she's wrong. It's not a question of her truthfulness. It's a question of her perception, okay? And you have to argue this to juries. And you can do this in a way without being hostile or insulting or treating this person as an adverse witness. He's actually very, very kind and sweet to her because he senses these two things. She is telling the truth. It's just that her perception is skewed. And we like her coming forward, but she's just wrong. She doesn't intend to be wrong, but she's just wrong, okay? And his attitude toward her and his cross-examination of her is perfect along those lines, and doesn't antagonize the jury, because there's nothing to antagonize him about her. She is telling the truth. It's just she's wrong, okay? Everybody got it? Yes. Let's take a look. This is My Cousin Vinny, 1992. Holy mackerel.
Mrs. Riley, when you saw the defendants, were you wearing your glasses?
Yes, I was.
Over here, dear. Would you mind putting your glasses on for us, please? Whoa. How long you been wearing glasses?
Since I was 6.
Have they always been that thick?
Oh, no. They got thicker over the years.
So, as your eyes have gotten more and more out of whack, as you've gotten older, how many different levels of thickness have you gone through?
Oh, I don't know. Over 60 years. Maybe 10 times.
Maybe you're ready for a thicker set.
Oh, no. I think they're okay.
Maybe we should make sure. Let's check it out. Now, how far were the defendants from you when you saw them entering the sack of suds?
About 100 feet.
100 feet. Would you hold this, please? Thank you. Sorry, excuse me. Sorry. Okay, this is 50 feet. That's half the distance. How many fingers am I holding up?
Let the record show that counsel is holding up 2 fingers.
Your Honor, please, huh?
Oh. Sorry.
Now, Mrs. Riley, and only Mrs. Riley. How many fingers am I holding up now?
Four.
What do you think now, dear?
Thinking of getting thicker glasses.
I want to give you a good way you can talk about this when you have perception issues and you have to analogize it to a jury, okay? It's very important, especially if the jury, the witness is sympathetic, that, you know, this person came in here, swore to tell the truth today, and told the truth. It's just that the truth is not objectively correct. She told the truth from her subjective standpoint, but it's objectively inaccurate because of perception. And tell the jury, they'll be able to picture this. It's a baseball game. Very close game. Tie score. It's late in the game. There's one out. There's a runner on third base. The batter hits a fly ball to left field. Okay? Not too deep. But everybody knows what's going to happen next. Everybody. All the fans know. All the players know. Everybody knows what's going to happen. The left fielder's getting ready to catch the ball. While he's doing that, he's positioning his body so he can throw the ball to the plate. The third base coach is getting the runner back on third base so he can tag up and go. The umpire has taken himself and put himself in a position so he can see, for the best possible vantage point, the play at the plate. Okay? It all happens now over a course of 2 or 3 seconds. The left fielder catches the ball, throws it on the fly to home plate. The ball, the runner, the catcher, everybody arrives at the same time, and there's a play at the plate. Okay? And the umpire makes a call. Safe, out, it doesn't matter. He looks at it, sees what he saw, and he has a ruling. Within a matter of seconds now, the television cameras show the replay. And they're able to show this replay at 10,000 frames per second. And it shows beyond a reasonable doubt that the umpire got it wrong. He got it wrong. This person actually is safe. And the umpire called him out. Okay? Well, human beings can't see things at 10,000 frames per second. But from the umpire's perspective, he saw what he saw, and he believed it beyond a reasonable doubt. He's just objectively wrong. Okay? Now, normally in court, we don't deal with objective truth. We deal with opinions. We deal with beliefs. Beliefs beyond a reasonable doubt are enough to convict somebody. Beliefs short of beyond a reasonable doubt must be not guilty. Here you have a situation where someone has a subjective belief and sincerely holds it. It's just objectively wrong. And it's nice when we can have evidence in court that is objectively truthful. It's always good when the objective and the subjective are the same. But every once in a while they're not. So despite the best motives and the truthfulness of the witness, it's just not accurate. Got it? What you're going to see now is testimony during a trial from a witness to a homicide, murder. Okay? What I'd like you to do, we're going to break this up and have a little exercise now. Let's watch the direct testimony, okay? And then we'll stop and talk about how we're going to structure the cross-examination. Okay? Simple? Let's take a look.
State your name for the record.
Omar Devon Little.
Mr. Little, how old are you?
About 29, thereabout.
And where do you live?
No place in particular, ma'am.
You're homeless?
And the wind, so to speak.
And what is your occupation?
Occupation?
What exactly do you do for a living, Mr. Little?
I rip and run.
You...
I rob drug dealers.
And exactly how long has this been your occupation, Mr. Little?
Oh, I don't know exactly. I venture to say maybe about 8 or 9 years.
Mr. Little, how does a man rob drug dealers for 8 or 9 years and live to tell about it?
Day to time, I suppose.
So you're saying you were at the opposite end of the parking lot when the assailant drew his gun?
Thereabout.
And do you see the gunman who killed Mr. Gant anywhere in the courtroom today?
Hey, yo, what up, Bird?
For the record, you are identifying the defendant, Marquise Hilton.
It's just Bird to me.
And Mr. Little, you had seen him many times before, had you not?
Yeah, we jailed together down the cut.
Yes or no, Mr. Little? Prior to the shooting, did you know the defendant?
I mean, I knew the man, but it wasn't like we was no friend or nothing.
So you would have no trouble recognizing him from a moderate distance, say 20, 25 yards in daylight?
Oh, no, no problem.
Mr. Little, do you recognize this particular weapon?
Yeah, that's Bird's gun, the 380.
You've seen it before?
Bird always flashing that thing.
So you'd actually seen it before the day in question? And on the day in question?
It was in Bird's hand.
When he shot at Mr. Gant?
Yes, ma'am. Bird covered them shiny little pistols.
Objection, Your Honor.
And the boy too trifling to throw it off even after a daytime murder.
You a lying cocksucker, man! I rip your heart out your gut!
The defendant will regain control. He will be forcibly restrained, and I will clear the court.
Now, before we dive into this, let's think. You watched it. You're paying attention. You're not taking notes. Okay? You got to trust your instincts. What's going on here?
Rips and robs, those armed robberies, you want to go into detail. You rob people, you use a weapon, you use a gun, how many times have you been convicted? Were you promised anything by the prosecutor? Obviously, we would know all this in a trial in advance, that witness or cross-examination, but, have you been promised anything by the prosecutor? What were you facing originally? They tell you you're facing 20 years. If you testify, what did they say? They would tell it to the judge, things like that. His ability to perceive, wear glasses, whether there was any animosity between him, whether he himself is a drug abuser, was he using drugs on the day in question? You're a drug, you rip off drug dealers, you take their money, yeah, you also take their drugs. And you use the drugs, correct? And were you on drugs that day? No, that was, how many days a week do you use drugs? But that day you weren't on drugs. You made all these observations without that. And things of that nature.
Joe, you hit something really important on the head. Think about it logically, okay? If the guy says that he's a robber, and he's been a robber for 8 years, okay? Well, then you say to yourself, why are you here today? If you're a robber, isn't the last place you want to be is with cops? I mean, aren't they the last people in the world you want to be having any dealing with and being a witness? Why are you here as a witness today? How did you get here? And I don't mean in a taxi, okay? How many times have you testified for the police before? Why are you testifying for the police? Did they offer you something?
That's the real issue. What is this guy doing in court? He's also, you're going to find, if you hopefully you would have the information ahead of time, but assuming you don't, there's something going on. He's got some kind of a deal cooking. There's something in this for him, and you've got to try to find out what it is. Right. Or if he denies it, at least let the jury know that he's lying. And also the factor that he's really enjoying this. It's like Bob said. The last place this guy wants to be is in a courtroom. The last people he wants to be is with the prosecutors and cops, unless there's something in it for him. And he's really enjoying burying this guy, and you just need to explore and find out why.
Well, that's the other thing. He says he's in the wind, all right? Well, are you in the wind in Baltimore? And isn't the reason you don't want to reveal where you live is because if the word gets out where you live, you're a dead man, right? Would you want to ask him in painstaking detail how it is that you go about ripping and running? What type of weapon do you use? Do you ever use a pistol? Do you ever use a 380 pistol? Have you ever shot anybody? Okay. What about his criminal history? Do you want to impeach him on his criminal history? Or at least talk to him about his criminal history? Now, what type of person does he appear to be? Does he appear to be a smart person or a stupid person or street smart person? Street smart. Okay. And so you're not dealing with a dummy. Not educated, but street smart. Okay, you agree? Okay. So you're going to have to take all this, don't underestimate this guy. You got to take all this into consideration. Okay? So this can be a fun cross-examination.
Because he's going to show off.
He's going to show off, and it's like, it's the tree with the branches. And you're going to start, I want to talk to you about how you rip and run. Okay? And he's going to start talking about it. And then from that, you're going to have, well, what kind of gun do you use? How many guns have you used? How many have you shot? You're going to have all these little branches going off to the side. And then you're going to talk about, what do you mean you're in the wind? Okay? And you're going to go off to the side and ascribe a motive to that. Then you're going to ask him, not ask him why, but how was it that you arrived here today with the police? What did you say to the police? What did they say to you? What are they offering you, if anything? Okay? And that's going to take you off another. So you're going to have a tree that has a whole bunch of branches on it. You've got to take your time with the witness and do a very structured cross-examination, making sure that you exploit targets of opportunity as they come up, right? Because you don't have perfect knowledge about this guy at all. So what you're going to try to do is build perfect knowledge based on by exploiting what you do know. All right. Now, I have stressed to you over and over and over again today the idea that your summation is nothing more than the flip side of your cross-examination, okay? And what you're going to see in this cross-examination here done by the attorney you're going to watch is a total conflating of the idea of cross-examination and summation. And you'll see the attorney literally giving his summation during the cross-examination. It's really the most catastrophic thing you could possibly imagine, all right? There's a time to give a summation, and there's a time to conduct a cross-examination, and they're not the same thing. One inexorably leads from the other. But he decides he's just going to posture for the jury and give his summation during the course of the cross-examination. He even goes so far as to turn his back to the witness and, give a speech to the jury instead of propounding questions and getting answers. At one point, he asked the jury, the witness, "Why should we believe anything you say?" That's not a question for the witness. That's a question for the jury. Again, he's conducting a cross-examination that is really a summation. He conflates the two of them with what you'll see are catastrophic results because he loses focus, doesn't understand the process of cross-examination, and very badly underestimates this witness, whom you guys have all picked up that he's a bright guy and street smart. You don't want to mess with this guy.
Yeah, like he's got probably a God's figure himself. Like he figures he can get away with anything.
He's been out doing street robberies for 8 years and he's still alive.
Exactly.
Okay. Let's take a look at the cross-examination of Omar.
The witness's last answer is to be stricken and disregarded by the jury.
Mr. Little, can I ask why you came forward in this case?
I told the police what I know.
Were you offered anything in exchange?
Like what?
Were you arrested? Were you going to be charged with a crime, and by testifying, did the police agree to drop those charges?
Nah, man, ain't even about that.
How many times have you been arrested as an adult, Mr. Little?
Sure, I done lost count. Don't have to take it personal.
Possession of a handgun, possessing a concealed weapon, assault by pointing, robbery, deadly weapon, possession of a handgun again, followed by violation of parole on weapon charges, followed by 1 count of attempted murder and use of a handgun in commission of a felony.
That wasn't no attempt murder.
What was it, Mr. Little?
I shot the boy Mike in his hind parts, that all. Fixed it so he couldn't sit right.
Why'd you shoot Mike in his hind parts, Mr. Little?
Let's say we had a disagreement.
A disagreement over?
Well, you see, Mike thought he should keep that cocaine he was slinging and the money he was making from slinging it. I thought otherwise.
So you rob drug dealers? This is what you do?
Yes, sir.
You walk the streets of Baltimore with a gun, taking what you want when you want it, willing to use violence when your demands aren't met. This is who you are. Why should we believe your testimony then? Why believe anything you say?
That's up to y'all, really.
You say you aren't here testifying against the defendant because of any deal you made with police.
True that.
That you're here because you want to tell the truth about what happened to Mr. Gant in that housing project parking lot.
Yep.
When in fact you are exactly the kind of person who would, if you felt you needed to, shoot a man down on a housing project parking lot and then lie to the police about it, would you not?
Hey, look, I ain't never put my gun on no citizen.
You are amoral, are you not? You are feeding off the violence and the despair of the drug trade. You're stealing from those who themselves are stealing the lifeblood from our city. You are a parasite who leeches off
just like you,
the culture of drugs. Excuse me? What?
I got the shotgun. You got the briefcase.
It's on the game, though, right?
A perfectly terrible cross-examination, and painful to watch, because he confuses the relationship between the cross-examination and the summation. All right, and there were 50 million questions. You know, Omar says to him, "Oh man, that's not what it's about." Well, the next logical question is, "Well, what is it about? How did you get here today? Who did you talk to? When did you talk to him? What did you say? How was it that you came off the street out of hiding and found your way to the police? And oh, by the way, what were you doing there that morning? Were you armed with any type of a weapon? You know?
Why do you care so much about it?
And by the way, you have used a pistol on another human being before when you shot Mike, haven't you? So shooting people is not something that's foreign to your experience in life. Make sense? I mean, you can have so much fun with this cross-examination. It can go on for as long as it needs to. I'm not suggesting you're going to be there for 5 days, but you're going to be setting up to make the same arguments that he made during summation. But he didn't set the foundation for it at all. He's just kind of jumping right into a summation, right? Painful to watch. This is also painful to watch, okay? A very famous movie in 1957. And we talked about this earlier today, but I just want to kind of stress what we're going to be looking at. So this is going to be a cross-examination of a witness. And the issue in the case is the witness's ability to overhear a conversation behind closed doors, okay? Now, there's a couple things I want you to pay attention to. First of all, when the questions are propounded, one of the things that the questioner does, Charles Lawton, is he engages in what I think is an extremely unprofessional tactic, and one that should have been subject to objection, and that is he's argumentative, meaning that he'll ask a question, get an answer, and then he comments on the answer, okay? Just right on the spot, okay? For example, he'll say something, the witness will come back with an answer, and he'll say, "Your candor is refreshing," or "That's how your mind works," or "You wanted it to be that way." These are not questions. He's making comments on the witness's testimony, okay? Now, when your adversary does that, you got to stand up and object that it's argumentative, okay? You can make all the comments you want, but wait till it's your time in summation. This is not the time to be summing up or commenting on the witness's answers. You'll have your chance to do that during summation. You've got to object to it, okay? So please make sure you do that. Now, he's not paying attention, okay? Remember I told you that the issue is her ability to hear a conversation behind closed doors. Notice in her body language, she's holding her hand up to her ear during the during the cross-examination, as if she's having trouble hearing him. This is a golden opportunity. What he could have done was said, "Your Honor, I note that the witness has her hand to her ear. May I have the court's permission to either raise my voice beyond conversational tone or leave counsel table and get close to the witness because I want to make sure she hears everything I have to say. She's obviously having difficulty hearing," okay? You've got to call this to the attention of the jury. I mean, you can't miss out on an opportunity like this, even if it's because the jury may have seen it, they may not have seen it, or maybe only one of them saw it or two of them saw it. You want to make sure that all of them know about it, because that's what this case is about, okay? Now, finally, notice the loss of focus, asking a witness a question that he doesn't know the answer to, and leading off with the question, why? Or in his case, why not? All right? Well, you'll see what happens.
Not just yet, Mrs. Mackenzie. Would you... Thank you. Miss Mackenzie, you have given evidence about 2 wills. In the old will, the will that was revoked, were you not to receive the bulk of Mrs. French's estate?
Aye, that's so.
Whereas in the new will, except for a bequest to you of a small annuity, the principal beneficiary is the prisoner Leonard Vole.
It'll be a wicked injustice if he ever touches a penny of that money.
It is entirely understandable that you are antagonistic to the prisoner.
Oh, I'm not antagonistic to him. He's a shifter, scheming rascal. But I'm not antagonistic to him.
I suggest you form this opinion because his friendship with your mistress cost you the bulk of her estate.
I never liked him.
Your candor is refreshing. Now, on the night of October the 14th, you say you heard the prisoner and Mrs. French talking together. What did you hear them say?
I hear what they actually said.
You mean you only heard the voices, the murmur of voices?
They were laughing.
What makes you say the man's voice was Leonard Voles?
I know his voice well enough.
The door was closed, was it not?
Aye, that's so.
You were no doubt in a hurry to get the pattern, so you probably walked quickly past the closed door, yet you were sure you heard Leonard Voles' voice.
I was there long enough to hear what I heard.
Come, Miss Mackenzie. I'm sure you don't wish to suggest to the jury that you were eavesdropping.
I know it was him in there with her. Who else could it have been?
Exactly. What you mean is that you wanted it to be him. That's the way your mind worked. Now tell me, did Mrs. French sometimes watch television in the evening?
Yes. She was fond of a talk or a good play.
Wasn't it possible on the evening when you returned home and passed the door that what you really heard was the television and a man and woman's voices and laughter? There was a play called Lover's Leap on the television that night.
It was not the television.
Oh, why not?
Because the television was away being repaired that week. That's why.
Here's another example of using why during a cross-examination. I can't imagine why you would ever do something like this, but, you know, people lose focus, they make mistakes, all right? But this kind of goes back to what we talked about before, that you're always, always, always being watched by the jury. And it's vitally important that your body language connote confidence and victory and righteousness and all those other things, okay? Even at the lowest point, you can't let them see you sweat. This is an example of an attorney who, besides asking the question why and getting a devastating answer, his body language communicates to the jury total and complete defeat. He's just a defeated man. The case is over, and he knows it, and he's communicating that to the jury. Okay? Let's take a look. It's John Travolta, 1998, a civil action.
Experts have testified in this court that your land, your 15 acres, is the most grotesquely polluted land in all of New England. Now, you have no idea how it got that way.
No, sir.
Does it upset you to learn this?
Very much so.
Really? Why?
And one last thing. Unless you know exactly what the answer is going to be, never, ever ask a witness why. Never. My factory is the oldest surviving business in Woburn. When the other tanners moved out, I stayed, even though for me that was a very big financial burden.
This is not the
I
question.
stayed because Woburn is my home.
Mr. Riley, Your Honor,
children's
this is
home.
not the question.
He's trying to answer it, Mr. Schlickman.
Well, he's not
You'll just
answering
let
it.
him.
That land has been in my family for 3 generations. That land to me is hallowed ground. So when you ask me, would I be upset if someone came onto that land and desecrated it? Land that's part of the town that I love? My answer to your question, Mr. Schichman, is yes.
I have no further questions, Your Honor.
As a lead-in to the techniques we're going to utilize for perfect information, I want to just spend a couple seconds with F. Lee Bailey. Again, he has a reputation of being a fabulous cross-examiner. He certainly breaks all the conventional tactical rules of cross-examination, and it's not unusual for him to ask why and how come and things of that nature. But he can get away with it because he's F. Lee Bailey. So he's going to talk a little bit about his philosophy behind cross-examination, and then we're going to see some examples of it from the O.J. trial. But the one I want you to pay particular attention to is the last series of questions that he asks Mark Furman. Now, remember, at this stage in the trial, they had developed perfect information, okay? They have it. They have it, and they have it cold. And he's going to have to own it at some point. But part of having perfect information is the setup. You've got to go through and set it up. So you'll see that the questions he asks him are intended to set him up. So when they lower the boom, it's going to be devastating. The case is going to be over, okay? And he'll ask him such things as, so anybody who would come in and say that you used that word in the last 10 years would be a liar, right? Yes. All of them? All of them. Okay? But remember, this is the setup for perfect information, perfect knowledge. Watch.
But a witness is not telling the truth. Will be in the eyes. And that's why I am adamant in training cross-examiners. You will not take your eyes off the witness. You will not have any notes at the podium. If there's something in writing you need to look at, reach back to the defense table and look at it, but keep your eyes on the witness. Period. That's it. Also applies to jurors when you're arguing and judges. And the essence of good cross-examination for lawyers well prepared is the speed with which it's administered. The speed is a very important element simply because even experienced witnesses should not be given time to think up their answers as you go along. They should be not pummeled, but questioned very rapidly, and that means not spending much time looking at your notes.
Were you present when he arrived from Chicago and they slapped handcuffs on him? Oh, well, yes. Well, when you slap handcuffs on someone, you're taking him into custody, aren't you? Not always, no. Oh, you have the right to handcuff a citizen without a criminal charge? There are instances you could, yes. Have you done that in the past? Handcuff people against whom there was no charge? Oh, well, there's times when people pick people out as suspects and you later identify that they were not the suspect and you would release them. But that wasn't the case here, was it? I don't know what the case as far as he was handcuffed. Did you really have any business at all in inspecting those bodies that morning? Yes, sir. All right, and where in the manual is it mandated that you do that? I have no idea. It isn't mandated in the manual anywhere, is it, Sergeant? I don't know. When was the last time you read the manual, do you remember? Cover to cover? About 15 years ago. And any part thereof? Probably 3 to 4 times a week. Okay. Are you therefore saying that you have not used that word in the past 10 years, Detective Furman? Yes, that's what I'm saying. And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman? That's what I'm saying, sir. So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman? Yes, they would. All of them, correct? All of them. Let's take a look at a cross-examination.
Oh, by the way, here's some examples of where you get perfect information. Sometimes it comes out about as a result of your direct. But prior sworn statements, prior unsworn statements but that are signed, admissions and confessions, published writings, video and audio, which is, the audio is what they had in the OJ case. Prior trial testimony, you saw that in the Gideon versus Wainwright matter. Criminal records, deposition testimony, letters, and other irrefutable evidence. Remember, no asking the last logical question. We'll let the jury figure all that stuff out. Okay? Now, let's take a look at a cross-examination where all these techniques are put into play. All right? You start off with the proposition that the attorney has perfect information. He's got it. All right? So watch how he goes through the setup to get him ready, and then he lowers the boom on the guy, okay? And notice the attitude that he adopts. Now, part of this, and this is why Raul Julia the late Raul Julia is just such a fabulous actor. When the witness is really squirming and really having a tough time, Raul Julia, there's a camera shot of him very quickly, but you see he's having a very difficult time suppressing a smile. He's enjoying this tremendously, okay, watching this witness squirm, okay? So, once he gets ready to lower the boom, now he can play whatever role he wants. All right? You'll see how he does it. Everybody got it? Now watch the process here that you can use with perfect information.
Now, Doctor, I call to your attention the results of the forensic chemist's analysis, States Exhibit 63.
Yes. Okay.
I think we might just nail this sucker.
And that report states that the specimen of semen taken from Miss Palemis's body has been identified as being of Mr. Savage's blood type. Am I correct?
You are correct.
It also indicates the presence of chemicals consistent with the use of a birth control device, a diaphragm.
It does.
Now, your opinion is that this was a staged rape?
That is my opinion.
And that the way it was done suggests the knowledge of investigative techniques.
Yes, that's what I told Mr. Moto.
And all of these deductions depend on the presence of spermicidal jelly in the specimen you sent to the forensic chemist, do they not?
Yes, sir.
How many autopsies do you perform in a week, Dr. Kumaga?
Oh, 1, 2, 10. It all depends.
Would it surprise you to know that you performed 18 autopsies in the 2 weeks surrounding Caroline Palemis's death?
No, sir. Sounds about right.
And given that number, isn't it fair to say that the specifics of any one examination may slip your mind?
I take notes while I do the autopsies.
Notes, yes. Well, these notes led you to tell Detective Lipranzer that the murderer was sterile. Looking back, you must have thought you were a fool to have escaped something so obvious as the use of a contraceptive spermicide.
All the sperm were dead. I didn't have the forensic chemist report about the spermicidal jelly. In absence of any other explanation, I thought the guy was sterile.
Do you recognize your notes of your autopsy of Miss Palemis, Dr. Kumaga?
Yes, sir. My signature.
Unless there is any objection, would you please read the short passage marked by the paper clips? Page 2, counsel. Read it out loud, please.
The fallopian tubes are ligated and separated. Ephemeral ends appear. Not right.
Your own autopsy notes? You did take them as you performed the procedure, do you not?
Not right.
I show you the records of Dr. Lubin, a gynecologist, and of the hospital where he performed this procedure on Miss Palemis 6.5 years ago. Would you explain to the jury what a tubal ligation is? Would you explain in layman's language what a tubal ligation is?
She had her tubes tied.
Is it possible for a woman with this procedure to conceive a child?
No way.
Can you think of any reason for a woman who had her tubes tied to use a spermicide?
No reason, no medical reason. I think of nothing.
Does it not follow, given these facts, that the specimen you sent to the chemist was not taken from the body of Caroline Palemis?
I can't account for it.
Oh, so you don't know what happened? Wherever you got that specimen from, Doctor, you sent it to the chemist while you were having secret communications with Mr. Molto behind Mr. Savich's back. Am I right?
Do you accuse me, Mr. Stern?
Sit down, Doctor. Oh, I think we have had enough unsupported accusations for one case.
Well, you have a situation where you've propounded a question to a witness, and the witness answers you with another question. The witness basically questioning you. Now, there's two ways you can approach this. My partner, what he used to do at Seaman Court, and when the witness would do it, he would say, listen, I ask the questions here and you answer them. That's how this works. You understand? Okay? I've always felt uncomfortable with that approach, and I think it's better. I think you can actually ignore yourself to the jury a lot more by saying, turning to the court and saying, Your Honor, could you please instruct the witness, or could you please instruct the witness as to his role, or could you please direct the witness to respond to my questions, that type of thing. Because it gives the illusion that the judge is in control of the courtroom when he's really not, you are. And number two, I just think it helps solidify that the witness is uncooperative and require judicial intervention in order to kind of get the truth out of him. Joey, you're propounding questions to a witness, and the witness answers you by asking you a question. Okay, how do you handle that?
I don't want to rely on the judge. I'm the one running the courtroom, not the judge. But I want the jury to know I'm running that courtroom. And if I call to him for help, like, Mommy, please, I can't control this witness, I need your help, I look weak and my client looks bad by inference. So, they talked before about, keeping control of the witness. I think a great way to keep control of the witness is by let them go off. I let them go off, and I sit there quietly. Sometimes I had a doctor once in the one med mal case I've tried, and he went off on a tangent, and he just wouldn't stop. And after 60 seconds, I said, okay. I pulled my chair over, and I sat down about 10 feet from, and I sat down, crossed my hands, and he went off for another 10 minutes, just shouting and screaming and making a complete fool of himself. And then when he finally stopped speaking, I waited a second, I looked up, and I said, oh, I'm sorry, are you done? Okay, thank you. I got up, I put the chair back. I said, now, what's the answer to the question I asked you? I don't remember. Okay, then you just repeat it. I believe that if a witness is really going off on a tangent, you just keep coming back. Okay, now what's the question what is the answer to the question I asked you? And they have to admit they don't know, and the jury sees they're out of control, and then they look bad. So I control them by letting themselves make a fool of themselves in front of the jury. I don't ask the judge to stop them. I let them go off in every direction. And then if it happens enough times, I'll say, is there a reason you don't want to answer the question that I'm asking you? And you know that by then the jury, you're watching a jury, they want to know the same thing. Why won't he answer that question? So I let the witnesses self-destruct. That's how I control them. Let them be out of control because that's to my advantage.
Now, this next clip requires a little bit of background. This actually happened, and it was enormously controversial. It was a big scandal when it occurred. It was on the front page of the New York Times the next day. And it deals with the activities of Associate Justice Robert Jackson when he was tasked by President Truman to go to Nuremberg and represent the United States as the lead prosecutor in the major war crimes trial, the war crimes trial in Nuremberg against the major Nazi war criminals, the leading one of whom was Hermann Goering. Now, I have to tell you, in fairness to Justice Jackson, he went there on the promise that he would be given the job as Chief Justice of the United States Supreme Court. That did not happen. Politics changed with the election of a Republican president in 1952. So he never really was able to get what he was promised. His performance at the trial will be forever remembered for two things. Number one, his opening statement, which was masterful and pure poetry.
Opening the first trial in history for crimes against the peace of the world imposes a grave responsibility.
And his closing statement. And they are really more historical documents than legal argument, where he really summed up why the trial was taking place and why it was important that these individuals be punished for their crimes. Okay?
If you were to say of these men that they are not guilty, it would be as true to say that there has been no war, that there are no slain, that there has been no crime.
They'll just go down in history as one of the most important openings and closings ever. All right, and he spent a lot of time rehearsing and dealing with them. I remember this one letter from his wife reminding him to talk slowly, deliberately, and he was very masterful. And you see the videos of his delivery. He's just absolutely fabulous. Okay. But for all the things that Justice Jackson was, one thing he was not was a trial attorney. He had no idea how to conduct a cross-examination. None. And you'll see this coming out in his cross-examination of Hermann Goering. Now, Hermann Goering was the highest-ranking Nazi on trial at Nuremberg. He had a long career of war crimes and political crimes and murder and things of that nature. He had quite a fabulous life. He was actually with the Red Baron, von Richthofen. He was part of that cadre of flyers in World War I. So he'd had a long association with the Luftwaffe, and was in fact during the course of the war the head of the Luftwaffe. As head of the Luftwaffe, one of his responsibilities was over the Stadtlagluft, the prison camps, where the flyers, either British or American, who were shot down were housed as prisoners of war. And it was his responsibility for their care, feeding, safety, and things of that nature, because that's your responsibility. By the same token, officers have a duty to try to escape, and that's countenanced by the law of war. And if they escape, you capture them, you put them back inside the Stalag, and that's just the way things go. Okay. Justice Jackson, though, wants to cross-examine him on a wide range of geopolitical issues that the Nazis were involved in, facts over which he has perfect knowledge, okay? But he doesn't know how to conduct a cross-examination. And he's dealing with an extremely articulate, intelligent witness, someone who he has completely underestimated, and someone for whom he feels a visceral hatred, okay? Now, I will tell you, this occurred on day 86 of the trial after Goering had testified for 3 days in his own case. And the results of this cross-examination were immediately broadcast back to the United States and made the front page of the New York Times the next day, and was just enormously embarrassing to the American side because of the incompetence with which Justice Jackson conducted this cross-examination. The questions that you're going to see propounded in the answer come from the trial transcript. Let's take a few minutes to take a look at Nuremberg.
You are perhaps aware that you are the only living man who can expound to us the true purposes of the Nazi Party and the inner workings of its leadership.
I am perfectly aware of that.
And you, from the very beginning, together with those who you were associated with, intended to overthrow and later on did overthrow Germany's previous government, the Weimar Republic.
That was my firm intention.
And upon coming to power, you immediately abolished parliamentary democratic government in Germany.
We found it no longer to be necessary.
Is it not true that people subsequently were thrown into concentration camps without recourse from the courts?
You must distinguish between two categories. Those who had committed some kind of treason against the new state were naturally turned over to the courts. The others, whom one might expect such acts, but who had not yet committed them, such as the functionaries of the Communist Party, who were attacking us in the thousands.
You've answered the question, thank you.
I need to explain further.
Well, you'll have the opportunity to explain further under re-examination from your own counsel. Now, did you prohibit all court review of the cause for taking people into what you were calling at the time protective custody?
That I answered very clearly, but I should like to make an explanation in connection with my answer.
Your counsel will see to that. Now, about the concentration camps.
Mr. Justice Jacks, the tribunal thinks the witness ought to be allowed to make what explanation he thinks right in answer to this question.
The tribunal thinks that you should be permitted to explain your answer now, and it will listen to that explanation.
I want to say that I issued a decree that those who were turned over to the concentration camps should be informed after 24 hours of the reason and allowed an attorney after 48 hours. This by no means rescinded my order that a court review of these measures was not permitted.
Now, by protective custody, you mean that you were taking people into custody who had not yet committed a crime, but you believed might quite possibly commit a crime in the future?
Yes, just as extensive protective measures are being taken in Germany today on
I didn't ask you about Germany today.
Mr. Justice Jacks,
this is poor preparation.
The witness may finish his explanation.
You say that you were against the attack on Soviet Russia, yet you gave no warning to the German people. You brought no pressure to bear to prevent the attack. You did not even resign to protect your place in history.
We were at war, and such differences of opinion could not be brought before the public during war. This was the case in your own country. As to your second question.
That will suffice.
I'm not finished. Secondly.
Your Honor, please.
The witness must be allowed to have his say.
Secondly, as far as my resignation is concerned, I do not wish even to discuss that. For I was an officer, a soldier. I served my country.
Now I ask
Thirdly,
you this. Your Honor, please.
Thirdly, I was not the man to forsake someone to whom I had given my oath of loyalty every time he was not to my way of thinking.
Your Honor.
It never, ever occurred to me to leave the Fuhrer.
Your Honor, the witness is adopting a contemptuous attitude toward this tribunal, which is giving him the trial that he never gave a living soul, nor dead ones either.
Objection, Your Honor.
I'm ready for the next question.
I think this is probably a good point to adjourn for the day.
And you notice the last question he was having so much trouble with was a compound question. He asked 3 questions in one statement. And the witness remembered all 3 of the questions. You're going to ask 3 questions in one thing. The witness has to have an opportunity to answer the questions, okay? But you notice that the form of his questions are wrong, and that he does not appear to have any strategy. He doesn't have any focus. He's just all over the place. And I think his visceral dislike for the witness comes through. Do you guys agree with me on that?
Yeah.
All right. So he was roundly criticized for this the next day, and it's one of the few black marks against him out of this whole transaction. So the next day, day 87, is now the turn of the British. Remember, there's 4 powers there, French and Russians also. Now the British. Sir David Maxwell Fyfe is going to conduct the cross-examination, and he's there. He's actually second chair. He was not the main attorney for the United Kingdom. And his background had been as a prosecutor at the Old Bailey, okay? Prosecuting murderers, kidnappers, thieves, liars, and all manner of petty criminal, okay? This was his life for years and years and years. This is what he did every day of the week. He knows his way around a courtroom, and he knows how to cross-examine a witness, just because he's a trial attorney. This is what he does, okay? Unlike Justice Jackson, Sir David has a strategy, he has a plan, he has a focus, okay? And he's not going to bother with all this geopolitical stuff. He's going to keep things real simple. He's going to focus on 2 things, okay? One is an incident that he knows will be very sensitive to Goering, okay? And the second is to demonstrate that Goering's love of Hitler is so unreasonable and so crazy that he's not worthy of belief in anything he says. Now, getting back to this first incident, you're all familiar with it. You guys know about this incident because you've all seen the movie, The Great Escape. Steve McQueen movie, you know, remember Steve McQueen jumping over these fences and all that. I'll tell you a little trivia about that. He did his own stunts in the movie, you know, with the motorcycle, except the insurance company would not allow him to do the very last jump. It was too dangerous and they were too far into the production. So they had a stunt double do the very last jump. But all the other jumps on the motorcycle, he did himself. You may recall that at the end of the movie, oh, now we got to start all over again because Rocco's here. Rocky, sit with me, okay? Give me company. I told my wife you were going to be here today. She got all excited. At the end of the movie, the British flyers who had escaped are all herded together by the Germans and shot. Do you guys remember that? That really happened, okay? So what he's going to do now, he's going to conduct a cross-examination on Goering on this narrow issue, this crime, okay? And watch how he does it. He doesn't talk about the execution of these guys or things like that. He doesn't mince any words. He constantly refers to it as murder, the murder of these airmen. And why this is particularly important is because Goering was in charge of the Stalin-Aloofs. Okay? He was responsible for their safety. He should not have let this happen. He's actually sitting on the witness stand. I don't know if you have noticed this. You should have picked up on the last one. He's wearing a Luftwaffe sky blue uniform. And notice how ill-fitting it is. One of the reasons that historically is he had lost a lot of weight once he went into prison. He came in very, very overweight and addicted to morphine, and they weaned him off the morphine, and he lost 40 or 50 pounds. So his uniform doesn't fit him right anymore because he lost so much weight. The uniform is shorn of all decorations and rank and insignia, but by the same token, there he is, okay? So let's take a look at the cross-examination of Hermann Goering done the next day, day 87 of the trial, by Sir David Maxwell Fyfe.
The decision to murder these young officers must have been taken very quickly, because the first murder actually took place on the 26th of March. You agree with that? It must have been taken quickly.
Ich nehme an, dass der Befehl, so wie ich später gehört habe, sofort.
I assume that this order, as I was informed later, was given immediately, but it had no connection with this document.
No, we're finished with that document now. We're going on to this, the murder of these young men. A Großfahndung, a general hue and cry, I think would be the English translation, was also issued at once in order that these men should be arrested. Isn't that so?
Das ist richtig bei jedem Ausbruch.
That is correct. Whenever there was an escape, and such a large number of prisoners escaped, automatically in the whole Reich a hue and cry was raised. That is, all authorities had to be on the lookout to recapture the prisoners.
So that in order to give this order to murder these men and for a Großfahndung, there must have been a meeting of Hitler, a Tenerate with Himmler or Kaltenbrunner, in order that that order would be put into effect. Is that so?
Das ist richtig.
That is correct.
I think you told the tribunal that right up to the end, your loyalty to the Führer was unshaken. Is that right?
Das ist richtig.
That is correct.
Do you still seek to justify and glorify Hitler after he had ordered the murder of these 50 young flying officers at Stalag Luft 3?
Ich habe weder den Führer Adolf Hitler zu rechtfertigen noch zu glorifizieren.
I am here neither to justify the Führer Adolf Hitler nor to glorify him. I am here only to emphasize that I remained faithful to him, for I believe in keeping one's oath not in good times only, but also in bad times when it is much more difficult. As to your reference to the 50 airmen, I never opposed the Führer so clearly and strongly as in this matter, and I gave him my views about it. After that, no conversation between the Führer and myself took place for months.
The Führer at Tenerate must have had full knowledge of what was happening with regard to concentration camps, the treatment of the Jews and the treatment of the people who were working, mustn't he?
Ich deutete vorhin an, dass es meine Meinung ist, dass der Führer
I already mentioned it as my opinion that the Führer did not know about details in concentration camps, about atrocities as described here. As far as I know him, I do not believe he was informed. But insofar as
I'm not asking about details. I'm asking about the murder of 4 or 5 million people. Are you suggesting that nobody in power in Germany, except Himmler and perhaps Kaltenbrunner, knew about that?
Ich bin nach wie vor der Meinung,
I am still of the opinion that the Führer did not know about these figures.
There's Hollywood, where you tell a good story, and then there's reality, all right? So I want to talk about reality for a second, because the incident you're going to see portrayed in this clip actually happened, all right? But I want you to understand the context of this. This is a trial that took place in 1858. Abraham Lincoln was the defense attorney. And in 1858, Abraham Lincoln was 49 years old, all right? This occurred in an era where he was engaging in the Lincoln-Douglas debates, which thrust him onto the national stage. This was during his Senate campaign. And during that era, the senators were elected by the state legislature. So, I mean, this was not a public election in the normal sense, but he was very much in the public eye nationally as a result of these debates. This is a mere 18 months or so before he's elected president of the United States. He was a superstar lawyer in Illinois, had a fabulously successful practice. He represented many railroad companies, which were his big money clients. He had argued more than 100 times before the Illinois Supreme Court. He had tried thousands of jury trials. He was a much sought-after arbitrator because he believed in trying to settle cases out of court, so to speak. This is a man who had really, he was just at the top of his game at this stage in his life. And as a lawyer practicing now for, more than 20 years at age 49, he knew what he was doing, okay? Now, the background of this case goes all the way back to when Lincoln was a very young man in 1834 when he settled in New Salem, Illinois. The town bully at that point was a man by the name of Jack Armstrong, and there was a rivalry between him and Lincoln. Ultimately, the two of them decided to settle it publicly with a big wrestling match, which Lincoln surprisingly defeated Jack Armstrong. Interestingly, they became very close friends after that and remained friends for years, for all the time that Lincoln remained in New Salem. But Lincoln left and moved on to Springfield and worked on his political and law career. Lincoln, though, heard about a homicide in 1857 perpetrated allegedly by Armstrong's son, William. Having heard about this and having still feelings for the family, Lincoln volunteered to come to the county where this was occurring, Cass County, Illinois, and represent him during the course of the trial. Now, this word Cass is going to be important. If it happened in Cass County, you'll see that the witness in this case is named Cass because of where the event took place. During the course of the trial, Lincoln utilized a technique that was extremely unusual in the 19th century, and that was utilizing judicial notice. Okay, now it existed, it was out there, but it was just not used all that much. But he utilized judicial notice, and at the end of the trial, the jury acquitted the defendant after one ballot. You'll see in the scene now that the way Hollywood wants you to look at it, you're dealing with a very young, inexperienced attorney trying this case, okay? Now, that's for public consumption. Let's look at it as lawyers, based on everything we've been talking about today. Abraham Lincoln has perfect knowledge, okay? He has perfect knowledge. So, we know what the procedure is going to be. You're going to do the setup, and then you're going to lower the boom. And during the setup and the lowering the boom, you can assume any role you want. You can be anything you want. You can be anybody you want. You adopt the role that's going to have the greatest impact with the jury. Okay? That's what's really going on in this scene. That's how I want you to look at it. Got it?
The defense wishes at this time to cross-examine the last witness for the state, Palmer Cass.
Palmer Cass!
Going with him.
What's he calling him back for?
Mr. Cass, Yesterday you identified Matt Clay as the killer of Scrub White.
Yes, I did.
You're sure of that?
Sure, I'm sure.
I just wanted to know. You say you were about 100 yards from the scene of the fight?
Just about, yeah.
Are you familiar with the land over there?
Yes, sir.
What's the nature of the layout?
Well, there's a little clearing.
Any trees?
A few.
Where are they?
Well, they're between the clearing and the fairground.
And you saw right through the trees?
No, sir. I was already through the trees when I saw them fighting.
Oh, I see. I suppose the clearing was all lit up by lights from the tar barrels.
No, sir.
How'd you see so well?
I told you it was moon bright, Mr. Lincoln.
Moon bright?
Yes, sir.
Of course, if it hadn't been moon bright, you couldn't have seen 100 yards, could you?
Of course not.
But you did see it.
I told you I saw it, didn't I?
What's he driving at?
And, the only reason you're telling us this now is because you feel sorry for one of the defendants.
Well, I didn't want to see them both get hung.
I don't reckon you'd lie about a thing like that. You can step down.
No further questions, Your Honor.
Oh, Mr. Cass, I forgot there's just one other question I want to ask you. Cass, what'd you have against Scrub White?
Well, nothing.
What'd you kill him for, then?
Kill him? Well, I don't know what you're talking about, Lincoln.
Yes, you do. Look at this. Go on, look at it. It's the Farmer's Almanac. Go ahead, look at it. Look at page 12. You see what it says about the moon? That the moon was only in its first quarter that night and set at 10:21, 40 minutes before the killing took place. So, you see, it couldn't have been moon bright, could it? You lied, didn't you, Cass? And you weren't trying to save these boys' necks, were you? You were trying to save your own, weren't you? Well, come on, weren't you?
No.
Well, then what'd you lie for?
I didn't lie.
Oh, yes, you did. It's as plain as a nose on your face, but why? Why did you lie about the moonlight?
I don't know what you're talking about, Lincoln.
I'll tell you what I'm talking about. You lied because you had a fight with Scrub White, but it wasn't about politics. You never mentioned politics. That was your first lie, wasn't it?
It was politics,
no,
I tell you.
You
it
were
was.
fighting about something else. Maybe it was money. Maybe you owed him money, or maybe he owed you some, or maybe he was getting a little graft here and there, and you wanted to get in on it.
That ain't true.
Maybe it was some girl.
No, that ain't right.
Well, what was it? It was one of those things.
No.
Something made you want to get rid of Scrub.
Well, you're crazy. Scrub was my friend.
Maybe. Just the same, you lied. Now, why? Come on, tell us. Why did you say you saw what happened when you didn't see?
What?
Well, I'll tell you what happened. You heard a row, and you saw the fight start, and you come running, and you saw that Scrub was still living. And right there on the ground, you saw the knife that Matt had dropped. And you bent over him and you picked up the knife. And your body hid what you were doing. And you stabbed him.
No, I didn't.
You stabbed him in the back and killed him. And these two boys, Matt and Adam, they each knew that he didn't do it. Therefore, each thought the other did it. And their mother, she saw the knife in Matt's hand, but she couldn't say so without putting a rope around his neck. And you killed him. No. And you lied. And your lie tripped you up.
No.
That crude, cold-blooded lie that was going to cover up the crime that you committed.
No.
The lie you can't deny. Now, can you? No. Can you? Answer me. You did kill him, didn't you? Didn't you?
I didn't mean to kill him. I was drunk. I was drinking all day. He was my friend. I didn't mean to kill him. Honestly, I didn't mean to kill him. I was drunk.
No more questions, Your Honor. Your witness.
I just want to show you an example of a cross-examination conducted by Perry Mason before he went over to the dark side. We actually teach a class on this movie, which is called Proof of Facts, but this is just for fun, okay?
Was the boat as far as from here to the bailiff?
I guess so, I don't know.
Do you mean to tell me you couldn't swim this little distance to this poor, weak girl and buoy her up till you could reach this boat just 15 feet away? I'll tell you one thing, you know you're lying. She was drowning and you just let her drown. She was sitting there defenseless in the back of the boat and you picked up this oar like this and you crashed it down on that poor girl's head like this. You pushed that poor girl into the lake. You watched her drown. Isn't that the truth?
No.
That's all, Your Honor.
This is a cross-examination in a murder trial. For some inexplicable reason, the defendant is going to exercise his right to testify. And now he's going to be cross-examined by the prosecutor, who has perfect information. He has perfect knowledge, okay? This is very painful to watch. Why this guy ever took the witness stand, I don't know. But you're going to see an extremely skillful cross-examination. But think about it in your own mind. You're sitting at counsel table with the prosecutor. He gets done. Everybody rests. Now you're going to stand up and give the summation. All of you sitting in this room right now could give a devastating summation in this case based on listening to this cross-examination. Okay? One additional thing I want you to pay attention to. He does very clever. It's really the proper way to do it. He has a document that he wants to utilize during the cross-examination. Okay? He publishes it to the jury so that the jury sees it up on the screen, and the jury is looking at it and has the same perspective as the witness. So everybody's looking at the same document at the same time, all right? Much more effective than keeping this stuff hidden.
Well, Mr. Dodson, you just agreed to 95% of the state's case except the part where you did it, didn't you?
No, sir.
You didn't?
No, sir.
I mean, you've been in here through this trial, right?
Yes, sir.
You've heard the proof we put on, right? You've been here.
Yes, sir.
So let's talk about it for a second. Let's talk about what you just agreed to, 95% of it, except the part where you did this. You left the house that night on CJ's bike, right?
Yes, sir.
You knew 9 people were in that house, either dead or alive. You said you thought they were dead, right?
Yes, sir.
You didn't call 911, right?
Yes, sir.
You didn't call your family, right?
Yes, sir.
You didn't call anyone at all that night, right?
Yes, sir.
At all.
Yes, sir.
You go to 1403 Silver and you put that bike in Sheila's shed, right?
Yes,
you can
sir.
agree on that?
Yes, sir.
You go to bed, right?
No, sir.
You got into bed, didn't you?
Yes, sir.
Okay. Did you go to work the next day?
No, sir.
On Sunday, while your family was in that house, you say dead, you didn't call anybody that day either, right?
No, sir.
Now, this entire time, you're living, right? You're living life on Sunday? Is that right?
No, sir.
Well, I mean, you're walking around, right?
Yes.
Went to dinner Sunday night, right, with, I think, Fat?
Yes, sir.
And during that entire time, did you call the police then? Just to let them know your family's bodies were in there, just so they could have a proper burial. Did you let them know that?
No, sir.
Okay. And let's just take a look at something here for a second. Your Honor, if I could publish Exhibit 3. All right. I mean, let's just be honest about what we're talking about here. Okay. This is what you saw when you went into the living room, right? I mean, you just told me that.
Yes, sir.
Okay. So you saw this
Yes,
and
sir.
left that house.
Yes, sir.
Sunday night, you go out to dinner, right?
Yes, sir.
Okay. Did you go to bed Sunday night?
No, sir.
At all?
No, sir.
You didn't sleep?
No, sir.
The entire time? What'd you do?
Stayed up.
You stayed up?
Yes, sir.
Did you call the police?
No, sir.
Did you tell your family about this?
No, sir.
Because you don't call the police, right?
No, sir.
Not even for your family?
No, sir.
Not even for a 2-year-old?
No, sir.
Not even for a 4-year-old?
No, sir.
Not even for a 5-year-old?
No, sir.
Not even for a 9-year-old?
No, sir.
Not even for a 2-month-old baby?
No, sir.
You don't call the police.
No, sir, I didn't.
Then you go to bed, you get up and you go to work Monday morning, right? I mean, you heard the testimony of that, right?
Yes, sir.
You went to work with your father.
Yes, sir.
Did you tell your father about that?
No, sir.
Did you tell him that his son was lying dead in the living room?
No, sir.
Did you tell your mother that her grandchildren were dead? Because you said you thought they were dead, right?
Yes, sir.
Did you tell them they were lying dead in that house, rotting?
No, sir.
I mean, you knew how many days had passed, right?
Yes, sir.
Since you saw that.
Yes, sir.
His initial first half of his cross-examination are not interrogatives, okay? They're statements, flat-out statements. One new fact per statement, and always looking for the witness to do is to ratify the statement, okay? And after he's got the witness locked in, that's when he starts asking the questions. You don't call the police, do you? Not even for a 1-year-old, not even for a 2-year-old, not even for a 4-year-old, you know? The only thing I would have put in there is so they could get a Christian burial, but that's, you know, now I'm splitting hairs. This next cross-examination it's painful to watch. I'm happy that it's not a New Jersey cross-examination. This apparently happened in Ohio. And I want to call to your attention a couple of things. The least problem here is exactly the opposite of what you just saw in the sense of exhibits. The defense attorney has an exhibit that he wants to impeach the witness on, all right? He has it on a little piece of paper, and he and the witness are having a colloquy about this document. Whatever they're talking about, whether it's significant or not, is going to be totally lost on everybody because nobody can tell what they're talking about except the two of them. The people who need to know, the jury, it's lost on them because they're not seeing it. They have no frame of reference. God forbid you should have an overhead projector in court, you know. And if you don't have an overhead projector, get a little easel and get like a 24 by 18 piece of paper. Give the guy a magic marker and have him draw it there so the jury can see what they're doing. The advantage, of course, is if they do it on a poster or something like that, they can take it back in the jury room with them. Stupidly, when I was a young lawyer, I had a witness doing that on a blackboard one day, and we came back to court the next day, and the blackboard had been erased. All right, duh. Think I ever did that again? All right. Now, this is the example I told you about earlier on with an attorney who loses not only control of the witness, but loses control over himself. The judge runs the courtroom, for better or worse, okay? And you have to kind of buy into that. This judge has a rule that the cross-examination and the direct examination of witnesses are to take place from a lectern. Judge's courtroom, judge's rules, okay? But this attorney wants to get into the personal space of the witness, all right? And the judge is not having any of it. So you're going to see an extremely uncomfortable exchange between the attorney and the judge, made worse by the intervention of a bailiff. And you'll see now that the whole trial is going to become not about the questions being propounded or the answers of the witness, but whether or not there's this fight between the judge, the prosecutor, and this defense attorney is going to continue. And the jury, instead of paying attention to what's going on, is watching this lawyer to see, is he going to cross this imaginary line and get himself in trouble again? What's going to happen the next time he approaches the witness? All stuff that's completely extraneous and has nothing to do with anything. One last thing, and I mentioned this to young lawyers. I see this a lot in oral argument, like up at the appellate division, where one of the judges will ask a question and they don't pay attention. They just keep right on talking. You got to learn to shut up and listen. You're in a trial. If your adversary interposes an objection, shut up. Let the judge rule in the objection, okay? Here, this attorney, he asked the same question 6 or 7 times in a row, never giving the witness an opportunity to answer, and just keeps barreling ahead in the face of a strenuous objection from the prosecutor, okay? And then, to make matters worse, doesn't even give the judge a chance to rule on it. It's just utterly, totally unprofessional. This is a very uncomfortable cross-examination, and I think just the attorney was having a bad day that day. Let's take a look.
Both of my sons left. Both of them left because they didn't want to be bothered with her.
They didn't want to be around her because she's a lesbian, correct?
No, sir. They accepted her being a lesbian. Everyone knew that she was gay.
Did you know that Justin pistol whipped her that night on the 5th? Hit her with a pistol. Did you know that? Yes or no? Did Detective Curry tell you that? That he took a photograph of her eye because Justin whipped her with a pistol. Did you know that?
Objection. There's been...
Move away from the witness.
Did you know that? I will.
I don't want you approaching the
That's
witness
fine,
again
Judge.
like
I'm
that.
fine.
You understand?
I understand.
Don't approach the witness like that.
All right, I won't.
Then stay where you're at and question from there.
All right. Did you know that? Did Detective Curry tell you that your son pistol whipped Donna? He ever tell you that? Yes or no?
Mr. Curry.
Did he tell you that? Yes or no?
Objection.
Did he tell you that?
Objection.
Did he tell you that? Yes or no?
Stop.
Objection.
Stop.
Your Honor, could I have an answer to the question?
Grounds?
This is actually an abuse of a witness as he keeps asking repeated questions, not giving him a chance to answer these questions. If he would keep it simple.
All right, I'll ask it again, real simple. Did Detective Curry, this gentleman sitting at the trial table, tell you that your son, Justin, hit Donna with a pistol in the face and gave her a black eye? Did he tell you that?
Yes or no? Could be a yes or no answer, sir.
No, sir.
Next question.
All right.
How about a circle?
All right, I'm gonna circle what you drew there, and that's gonna be where you were when the shots were heard, correct? I circled it.
Okay, wait a minute. See this door here?
Wait, don't write it on this thing, because I don't want markings on it.
I'm more here, sir.
Well, sir, I asked you to put DL where you were when you heard the shots, correct? Did I ask you that?
I signed, sir. I just put it there, but then I'm telling you.
Excuse me again, if Mr. Duff would step away, it seems to
I
be...
think I'm being very gentle with the man.
No, I
don't. Mark it out. Go back to the
You
podium.
have marked on
Question
here.
from the podium.
You have marked on here with DL where you were when the shots were heard. Yes or no? Did you do that? Yes or no?
It's not right by the door, sir. I put it right. If you can...
You want to remark it?
Yes.
Remark it, sir. DL, please.
The person to hand this back
Sir, you can't get it down here. See, this is where my mark is.
Don't push me, Jensen.
Excuse me, sir. This is where my mark is. But this is the opening of the door, right? And this, I'm right by the opening of the door, right here, sir. See, and it's still
Put a
right
circle
there.
around that, sir. Thank you. All right. Thank you. So, fine. All right. Now, how many feet from your... Is that your bedroom door that you're by?
Yes, sir.
You want to take it to me? Want me to?
I'll take it.
I need to see when he does it. That's the problem. There's no one to project. All right. Now, the couch. Is that indicated on that drawing where he was laying?
I can tell you, I saw in Passaic County, I'm going back now about 40 years, I won't mention names because everyone will know the attorney involved. The attorney was cross-examining a cop, and he was implying that the cop had lied. Now it wasn't a great cross-examiner, but he was an experienced one. And I swear this happened. He implied that the cop lied and he didn't, whatever the motivation was attributing him. And the cop answered when he says, "Isn't it a fact that you lied when you said that?" And his answer was, "Are you accusing me of lying?" And then the officer says, and the attorney said, "Yes." He says, "Do you know what that means for me?" "Yes." "You know I could lose my pension if I lied?" "Yes." "Do you think I knew this man before?" "No." "You think I'm out there just committing crimes?" And he started cross-examining the attorney, and he was doing a very good job, and the attorney kept answering the cop's questions, and the cop cross-examined him into annihilation in the case, and the case was over. It was a great cross-examination, but the witness did it of the attorney who kept answering his questions and playing servile to his domination.
How do you handle that, Jerry, when a witness answers with a question?
I don't answer any questions from witnesses. I do what your former partner did, and make it very clear that I'm answering the questions and that he's there under oath to answer them. And I think this is a perfect example of there can be no hard and fast rule. You've got it's what's appropriate for your personality. It's what's appropriate for the personality and the presentation of the witness. It's appropriate for the questioning area that you're involved in.
And the jury's reaction to the witness, too.
And the way whether they like the witness or they don't like the witness, and how smart the witness is. Because he's right, there's some witnesses you can let go off and they will just self-destruct. But there are also some witnesses that you do not want making their case to the jury because they're just too smart and they're able to communicate too well and they'll bury you. So it's really, you've got to, it's like they were saying earlier, this is one of those advantages you either take or you let go while you're in the middle of cross-examination. In some situations, if the guy's too smart and he's going to make too many points with the jury, you got to fight and do whatever you do to shut him up.
Okay. Our last clip is from a classic movie. You guys have all seen this, right? 1,000 times. All right. I want to just kind of have you analyze it like lawyers and not like movie fans, okay? Now remember, this is 1954, and there's a certain 1954 morality associated with right and wrong, and wrongdoers can never get away with doing wrong, okay? So at the end of the movie, there's a little victory party going on among the sailors who've been acquitted at trial. And Jose Ferrer, as their attorney, I think his name is Barney Greenwald or something like that, some innocuous name, shows up, and Barney's drunk and expresses that he feels very guilty about what he has done, okay, in defending these guys. He says, I much rather would have prosecuted. And the sailors are really kind of taken aback by this. He said, you did such a great job for us. It was such a difficult case. And Barney says, no, it was like shooting fish in a barrel.
Well, the case is over. You're all safe. It was like shooting fish in a barrel.
Okay? Now, we as lawyers now know what he means by that. Because when you have perfect knowledge, it is shooting fish in a barrel. Okay? There's no challenge to it. And he has perfect knowledge about this witness. Got it? Let's take a look at what you can do when you have perfect knowledge.
Good afternoon, gentlemen. I assumed command of an extremely sloppy, badly handled ship. I was determined to bring this ship into line. Lieutenant Merrick, I may say, opposed me from the very first. Maybe he thought I was crazy to keep trying.
In your judgment, was your ship on the verge of foundering when the executive officer assumed command?
Well, now, as you gentlemen know, a typhoon is an extreme hazard at all times, but the ship was riding well. Lieutenant Merrick, however, went into a panic and ran amok. He acted under the delusion that he and he alone could save the ship. Ensign Willis Keith, a totally unreliable and disloyal officer, combined with him against me at this crucial time. It was bad luck for them, really. I bear them no malice. I'm extremely sorry for them.
No more questions.
A word of caution before you proceed with the examination, Mr. Greenwald. The court recognizes that the defense is compelled to try to challenge the competence of Lieutenant Commander Quigg. Nevertheless, all the requirements of legal ethics and military respect remain in force.
Thank you, sir. Mr. Quigg, during a period when the Kane was towing targets, did you ever steam over your own tow line and cut it?
Objection. I beg the court's indulgence, but I must say the defense outrages the dignity of this proceeding.
The judge advocate wants the defense to switch to a guilty plea. He thinks the report of the psychiatrist closes the case. But I say it is up to you line naval officers, not doctors, to judge the captain's performance of duty. And I must review that performance of duty for the Navy to render a judgment.
Objection overruled.
Now, sir, did you ever steam over your own tow line and cut it?
Well, I for one, am happy to dispose of this particular slander. During the time we were towing the target, I noticed some anti-aircraft bursts close aboard, and naturally, I turned to avoid them.
And you continued to turn in a full circle?
Well, my helmsman, a very unreliable man, failed to warn me that we were coming around 360 degrees. I caught it in time and instantly reversed course. To the best of my knowledge, we didn't steam over the tow line.
I see. Now, besides the anti-aircraft bursts, did nothing else distract you?
No, not that I recall.
Well, Captain, weren't you engaged in reprimanding a seaman named Dlugac at length for having his shirt tail out while the ship turned 360 degrees?
Well, yes, I reprimanded him, but that only took 2 seconds.
Mm-hmm. Now, on the morning the Kane escorted attack boats of Marines to the beach, did your orders include dropping a yellow dye marker?
I don't recall.
Did you drop a yellow dye marker?
I don't recall.
Well, now, Captain, didn't you steam several hundred yards ahead of the attack boats, drop a yellow dye marker, and retire at high speed, leaving the boats to make the beach on their own?
The question is abusive and flagrantly leading.
Mr. Greenwald, there can be no more serious charge against an officer than cowardice under fire.
Sir, may I make one thing clear? It is not the defense's contention that Lieutenant Commander Queeg is a coward. Quite the contrary. The defense assumes that no man who rises to command a United States naval ship can possibly be a coward, and that therefore, if he commits questionable acts under fire, the explanation must be elsewhere.
You may resume your examination.
Captain, you seem to be the victim of constantly disloyal officers.
Now, I didn't say that. Only some of them were disloyal.
Mr. Keith and Mr. Merrick, for instance.
Yes.
Now, Mr. Queeg, this is a fitness report you wrote on Mr. Merrick, 1 July 1944, 1 month before he relieved you. Do you recognize it?
Yes, I do.
Would you mind reading your comments on Mr. Merrick? I don't believe the court can hear you, Mr. Queeg.
This officer's improved in performance of duty since his last fitness report. He's consistently loyal, unflagging, thorough, courageous, and efficient. He is recommended for transfer to the regular Navy. Now, in relation to that report, I'd like to say that...
Thank you, sir. Captain, did you ever turn your ship upside down in a vain search for a key that did not exist?
I don't know what lies have been sworn to in this court, but I'd like to set you straight on this matter right here and now. A key definitely did exist.
May it please the court, the witness is understandably agitated by this ordeal, and I request a recess to give him a brief...
I don't want a recess. I'll answer all questions right here and now.
Did you conduct such a search?
Yes, I did. As usual, my disloyal officers failed me and the key couldn't be found.
As a matter of actual fact, wasn't this whole fuss over a quart of strawberries?
The pilfering of food in large amounts or small is one of the most serious occurrences on board ship.
Yes, but didn't you learn the mess boys had eaten the strawberries and that you were conducting a search for an imaginary key?
I repeat, the key was not imaginary. And I don't know anything about mess boys eating strawberries.
Captain, have you no recollection of a conversation with an Ensign Harding just prior to his leaving the Cane?
What about it?
Well, didn't Ensign Harding tell you that the mess boys ate the strawberries?
All that I remember is that he was very grateful for his transfer. His wife was ill in the States.
Captain, do you know where Ensign Harding is now?
Well, I have no way of knowing.
Ensign Harding is in San Diego. His wife is fully recovered. He has already been summoned and can be flown up here in 3 hours, if necessary. Would it serve any useful purpose to have him testify?
No, I don't see any need of that. Now that I recall, he might have said something about mess boys, and then again he might not. I questioned so many men, and Harding was not the most reliable officer.
I'm afraid the defense has no other recourse than to produce Ensign Harding.
Now, there's no need for that. I know exactly what he'll tell you. Lies. He was no different from any other officer in the wardroom. They were all disloyal. I tried to run the ship properly with the book, but they fought me at every turn, no more, no less. But they encouraged the crew to go around scoffing at me and spreading wild rumors about steaming in circles and then old Yellowstain. I was to blame for Lieutenant Merrick's incompetence and poor seamanship. Lieutenant Merrick was the perfect officer, but not Captain Queeg. But the strawberries, that's where I had them. They laughed at me and made jokes, but I proved beyond the shadow of a doubt and with geometric logic that a duplicate key to the wardroom icebox did exist. And I'd have produced that key if they hadn't pulled the Cane out of action. I know now they were only trying to protect some fellow officer and... Naturally, I can only cover these things from memory. If I've left anything out, why, just ask me specific questions and I'll be glad to answer them one by one. One by one.
You see what you can do when you have perfect knowledge, guys?